Everybody ready? All right. All right, good morning, everyone. This hearing is now in session. I am Brian McGinn, the hearing examiner pro tem for the city of Liberty Lake. The hearing examiner is an attorney retained by the city to hear and decide land use applications and appeals and other quasi-judicial matters. The hearing examiner's office is independent of the city planning division. My assistant to my right is Kim Thompson. She'll act as the clerk today. Today's date is Tuesday, September 13, 2022. It's approximately 9 a.m. The item scheduled for hearing at this time is hearing examiner file number APP-2022-0001, which concerns an appeal of a SEPA determination and a binding site plan. These matters are designated under Liberty Lake numbers LUA 2022-0004 and BSP 2022-0004. Respondent Neighborly Development LLC submitted an application for a binding site plan to divide approximately 21.43 acres into 6 lots for a mixture of uses, including multifamily, commercial, and office and other uses. Neighborly Development LLC is represented by Mr. Nathan Smith of Cutac Rock. On July 1st, 2022, the city of Liberty Lake issued its findings of fact, conclusions, and decision approving the binding site plan. At the same time, the city issued a mitigated determination of non-significance for the binding site plan. The city of Liberty Lake is represented by Mr. Todd Hume of Witherspoon Brassage McPhee. On July 15, 2022, the appellant city of Spokane Valley appealed both the MDNS and the binding site plan. That appeal is the subject of today's hearing. The city of Spokane Valley is represented by Mr. Ken Harper of Minky Jackson Buyer. The procedure we'll follow today is generally as follows. First, we'll have opening statements by each party at your discretion. Next, we'll have presentation of arguments and evidence by the appellants. Following that, we'll have presentation of arguments and evidence by the respondent, City of Liberty Lake. Following that, we'll have presentation of arguments and evidence by the applicant. And after those presentations and arguments, we'll allow some time for rebuttal. And at the end of the process, we'll have closing arguments by each party. The hearing is being conducted in accordance with the procedures set forth in the Liberty Lake Municipal Code and the hearing examiner system adopted as Chapter 9 to that code. The hearing examiner's decision is final unless it is timely appealed. Hearing examiner decisions are subject to appeal to Superior Court, usually within 21 days after issuance of the hearing examiner's written decision. Appeal procedures are set forth in the Liberty Lake Municipal Code and/or Washington State statutes. All testimony today will be given under oath. I'll administer the oath on each witness as we proceed through this hearing. That's the process in a nutshell. I don't know if does anyone have any procedural questions or have any proposals they want to make in terms of process if they don't particularly want to follow the process I laid out. Go ahead, Mr. Hume.
Thank you, Mr. Hearing Examiner. Todd Hume speaking for the record. Point of order, would it be okay if we had the applicant go ahead of the city?
Of course.
Just switch those roles. I think having the applicants, traffic experts, sort of on before the city speaks would be, I think, more informative for you.
That work for you, Mr. Smith, I assume?
That's fine for us. Thank you.
All right, that makes sense to me. I just took a guess.
Okay.
All right. Any other points of order or procedural questions, Mr. Smith?
Apologies. Did I hear that Ms. Key is going to be presenting her staff report at the first instance, or is that going to occur later?
I did not say it that way, but we can do it that way, Ms. Key. What would you prefer to do? What would be more?
I'm happy to kick it off with the staff report. I think it lays out the foundation for everyone else's arguments.
That sounds good to me. I frequently do that. I just didn't happen to think to do it that way this time. So we'll start with the staff report, then we'll have the appellant, then we'll have the applicant, then the City of Liberty Lake. Sound good?
Mm-hmm.
All right.
And one other thing, Mr. McGinn.
Yes.
Yesterday, we received an email from Mr. Smith adding a witness. So since I sent out the exhibit list yesterday, that was added as exhibit 21. And Ms. Key gave us her presentation, which is now exhibit 22.
Okay, very good. All right, then let's go ahead and get started. We'll begin with the staff report. Ms. Key, go ahead whenever you're ready.
Thank you. Please let me know if I'm not speaking into the microphone because it doesn't pick it up well if I don't. For the record, my name is Lisa Key. I'm Director of Planning, Engineering, and Building Services for the City of Liberty Lake. And I am presenting the staff testimony and an overview of the project. Again, the proposal summary, this was the applicant applied for a mixed-use preliminary binding site plan. So basically, they were requesting, as the hearing examiner had indicated, the division of a 21.43 plus or minus acre parcel into 6 lots, 3 of which would be multifamily, 3 of which would be commercial. There's a little more commercial acreage than multifamily, and that is a requirement for multifamily as a limited use in the particular zone that it's in. And there is a copy of the binding site plan. Because city code and Washington code do require a SEPA review as part of a binding site plan application, the applicant based their SEPA on planned future development. What's known as the 14 multifamily buildings with a total of 288 units. Also proposing a community center. They also are anticipating commercial and office space uses and recreational amenities. Again, that is their best case plans, but there is no crystal ball. The subject property is located at the intersection of Country Vista Drive in the city of Liberty Lake and Kramer Parkway. And you see it on the map there. I would also point out that it is directly adjacent to a project that's currently under construction. The Kramer Parkway extension and overpass to connect Mission Avenue and Country Vista. And so that project is currently under construction. Also, just to give you a sense for, they are located to the east of Ridgeline High School. In the lower left-hand corner of the screen, you can see the intersection of Sprague and Barker Avenue, as well as the intersection of Sprague and Appleway. You can also see to the north the interchange that is the Harvard Road interchange. It's listed as North Liberty Lake Road on this map, but that's just the scout didn't exactly record it correctly. My apologies on that. Again, the procedural timeline, the application was submitted on the 18th. We did not make a determination of completeness until the 17th of May, when the notice of application was sent out. The close of the SEPA comment period was 5/31, so May 31st. And we did issue the written decision on July 1st. Actually, the delay was that we were waiting for the applicant to submit required revisions for the binding site plan. And I should note that the notice of application included both the SEPA checklist and the trip generation and distribution letter. The comment period closed on July 15th, and about an hour before the close of the appeal period, City of Spokane Valley filed their appeal. And so today is the hearing date. I wanted to make a point that we did have a number of agencies that commented. Several of the agencies' comments specifically resulted in changes to the SEPA or to the binding site plan. Comments from Ecology, from Spokane Tribe of Indians, and from TransCanada Energy all actually resulted in conditions, mitigating conditions on the MD&S. We did also receive comments from City of Spokane Valley. Jeremy Clark submitted comments on the 31st, the last day of the comment period. And he indicated that based on the trip generation and distribution letter, there were estimated trips on the South Barker corridor and impacts to the Sprague. And he indicated that there were impacts to Sprague Barker intersection, Appleway Barker intersections. These intersections are within the South Barker impact fee area that the City of Spokane Valley has created. And under the City of Spokane Valley standards, a TIA would have been required. not under the city of Spokane Valley's engineering design standards, however, and based upon the valley's estimated impact fees, the letter stated that the city of Liberty Lake must impose traffic mitigations. Interestingly, on the 1st of June, so the very next day, Jeremy also issued a letter from the city of Spokane Valley that the valley was bringing forward the South Barker Corridor Impact Fee Rate Study for Liberty Lake for adoption by at a special city council meeting in the valley on June 14th. The letter stated that city of Spokane Valley may not impose an impact fee on an adjacent jurisdiction, and that the imposition of impact fees would require an interlocal agreement if so desired. The study on which this was based also had that statement in the introduction. So just to go into the staff analysis, I'm going to cover 3 areas. Number 1, we identified a procedural error in the Valley's appeal filing. Number 2, I want to talk about the appeal of the SEPA threshold determination and share with you both the basis for that threshold determination, and also respond to allegations of SEPA legal errors on my part. I also want to address a response to allegations of legal errors in the issuance of a written decision for the preliminary binding site plan. Again, the allegations suggest that the city of Liberty Lake did not follow their own code. Yes, sir.
Lisa, can I stop you for a second? Mr. Hearing Examiner, can I, here's something that might be helpful. To the extent that in the staff report, Ms. Key is talking about sort of her own testimony about what she considered or didn't consider. Would we want, just for the future benefit of a future record somewhere, do we want to swear her in?
That's probably a good idea. I was expecting more of an overview, and no, we are getting into testimony now, basically. So yeah, Ms. Key, will you please raise your right hand? Do you swear from the testimony you're about to give will be the truth?
I do.
All right, thank you. Go ahead.
Thank you. So first, to address the procedural errors that we identified in this appeal filing. So Liberty Lake Development Code 10-6A7C7, which is our environmental regulations, prohibits the consolidation of a SEPA appeal with an underlying action that is a ministerial permit decision that does not require a public hearing. So our development code in City Development Code 10-4B3B identifies binding site plans as a type 1 action, and type 1 actions are specifically defined as generally administrative decisions that usually require SEPA with minimal notice requirements, and decisions are made by the zoning administrator or his/her designee without a public hearing. The type 1 procedure is used when there are clear and objective approval criteria, and applying city standards and criteria require no use of discretion. So the city of Spokane Valley, when they filed their appeal, filed only 1 application, 1 statement, and paid only 1 filing fee. Liberty Lake PEB's fee schedule specifically states that each action for which there is a listed fee will constitute a separate action, i.e. each variance request is a separate action. So in this case, each appeal action was a separate action. Liberty Lake Development Code 10-4G2H2 states, any notice of appeal not in full compliance with this section shall not be considered. So I bring that to the hearing examiner's attention. Obviously, we proceed, that will be a matter for you to determine, I would assume, in your written decision. But I did want to bring it to your attention. Now to focus on the basis for the SEPA threshold determination. So the city of Liberty Lake did follow the procedural requirements of SEPA as established in WAC 19711. And we used the following to assess traffic impacts within our jurisdiction, the city of Liberty Lake. Our Liberty Lake Network Analysis and Corridor Study Update, which was updated in 2020, the City of Liberty Lakes 2023 through 2028 Capital Facilities Plan and Transportation Impact Program, and the Harvard Road Mitigation Plan in 2013, the 2013 update, which was technically adopted in 2014. We also considered comments from Ecology, Spokane Tribe of Indians, and TC Energy that were incorporated into that threshold determination. Comments from City of Liberty Lake, Avista, and TC Energy also required revisions to the preliminary binding site plan. As based upon the results of the trip generation and distribution letter, the City of Spokane Valley presented two alternatives to mitigate reported impacts to the South Barker corridor. One was based upon the South Barker corridor impact fee cost per trip by segment analysis, which provided a mitigation fee of $257,872, which they indicated would apply, or as based upon the South Barker corridor transportation impact fee rate study for Liberty Lake, which had not been adopted at the time they made the comment. Mitigation fees for $191,844 would apply. So in reviewing this comment, City of Liberty Lake determined that the requested impact fees were not required and in fact not permitted based upon the requirements of WAC 197-1160. And specifically, WAC 197-11-661A requires that mitigation measures be based on policies, plans, or regulations formally adopted by the city as a basis for the exercise of substantive authority. So first of all, the impact fees associated with the South Barker corridor impact fees for Liberty Lake had not even been adopted by the City of Spokane Valley at the time they made their comment. Secondly, neither of the studies that they referenced were ever adopted by the City of Liberty Lake. And so obviously in the exercise of Liberty Lake's substantive authority, we don't have a basis for imposing those fees. WAC 197-11-6601C also requires that mitigation measures shall be reasonable and capable of being accomplished. Well, the City of Liberty Lake has a record of challenges to the methodology associated with those studies, number one, and that was there's a record of that that's appended to my staff report. Number two, without the fee studies having been adopted and without there being an interlocal agreement, there was no way to apply those mitigation measures to include those as a mitigation measure. And there was no mechanism for how those fees might be paid. So if during project review, it's determined that adequate environmental analysis, protection, mitigation for specific adverse impacts from the project area are addressed through other adopted regulations and plans, WAC 197-11-6601G actually prohibits additional mitigation measures under SEPA. So the two intersections that were identified to be impacted, one was the South Barker Sprague Avenue intersection, the roundabout for which was actually under construction at the time the time this review was going on, and has since been completed. It was in fact completed on August 24th. So again, the resolution by the applicant's own testimony or their own filings, that intersection would be operating at a level of service A at the time this developed, based upon the fact that that's already been constructed. The other intersection that they identified is the Appleway Barker Road intersection. That's actually included in their transportation improvement plan for construction in, I believe it's 2024, starting in 2024. And that actually, that is in their transportation improvement plan, in part because of a number of projects that they have already approved, their pipeline projects that were not, that caused that, that intersection to fail. Again, because they have adequately planned and planned for the mitigation of that intersection. Again, I don't believe that the city of Liberty Lake could in any way, shape, or form require a mitigation for something that's already been being addressed. So again, response to the alleged SEPA errors. So first of all, the first allegation was that the MDNS is erroneous because it failed to mitigate probable environmental impacts. I would point out that SEPA does not demand a particular substantive result. It's a process-based statute, and I believe our attorney will speak more to that point. Secondly, the most important aspect of SEPA is the consideration of environmental values. And the city of Liberty Lake did consider the potential environmental impacts in its decision. Also, information contained or not in the SEPA checklist and trip generation and distribution letter as provided by the applicant cannot be used to assign fault to the city of Liberty Lake's MDNS. And again, I believe Todd will talk more about that under Lovelace v. Yantis. Continuing with the allegations as to SEPA errors, there was an allegation was made that the environmental checklist did not contain adequate information to make a threshold determination. So first of all, I'd like to point out that nowhere in the checklist, the trip generation letter, or the MDNS is it ever stated or suggested, much less implied, that the affected geographic area was limited to the city of Liberty Lake as stated by the city of Spokane Valley. The environmental checklist and trip generation and distribution letter did contain sufficient information to assess the impacts as demonstrated by COS, the city of Spokane Valley's comments and subsequent filings. I mean, clearly there was enough information. They made the comments, they provided their own analysis. And the lack of specificity regarding commercial uses is not a fatal flaw. It's actually a relatively common issue with commercial subdivisions and binding site plans. And as is typical, when we actually do get a development proposal, we refer back to the SEPA review. And if there is a greater intensity of use than was considered in that original SEPA review, we do require an additional SEPA review. In fact, I believe that is called out for all of our applicants during our pre-application meetings. Also, there was an allegation that the project will cause level of service failures in city of Spokane Valley. Given the recently completed Sprague-Barker roundabout and the planned Appleway-Barker intersection improvements, mitigations for potential impacts in the city of the Valley have already been addressed. And again, also, city of Liberty Lake failed to require mitigations for impacts in the city of the Valley. And again, I would say see the response and analysis under WAC 197-1160. Also, there was an allegation that Harvard Road mitigation is not a valid SEPA mitigation. So first of all, RCW 82.202 020.020 does allow for voluntary impact fees. Harvard Road fees are a voluntary fee assessed against the capacity impacts within the city's 6 square mile corporate boundaries. Some impact fee areas in larger cities are much larger than the entire corporate bounds of our city. And it's done on a per trip basis based upon the city's build out analysis. Again, impact fees were not paid under duress. The applicant had a choice to complete a TIA and pay their proportionate share of specific impacts, or participate in Harvard Road mitigation fees in lieu of a TIA. And the city has code that supports that decision. Harvard Road mitigation analysis is updated in 2014 and supported by the City of Liberty Lake's 2020 network analysis provided evidence of the fees being reasonably necessary. And then also there was an allegation that we did not demonstrate the connection between the project and Harvard Road mitigation. And all I can say is that the Valley's offered no such evidence, and the burden of proof rests with them. We have studies that look at our city through the lens of build out. And again, which is feasible, which is a feasible analysis when you're a small city. As for allegations, the alleged legal errors in the issuance of the written decision, Liberty Lake cannot use a binding site plan to subdivide residential properties, was the claim. RCW 58.17.035 does allow for the use of binding site plan process for divisions of commercially or industrially zoned properties. The subject property is zoned M2, which is community center mixed use. Our comp plan defines that zone as community centers may have a mix of uses, including commercial, civic, light manufacturing, or industrial, office, recreational uses, and residential uses when associated with other permitted uses. So residential is only a limited use in this zone. City Development Code 104D-13 actually establishes the regulations for use of binding site plans within the city and specifically calls it out for divisions of land for purposes of sale or lease of commercial, industrial, or mixed-use zone properties as provided for in RCW 58.17.035. The Valley's also alleged that that a TIA was required by our engineering design standards. Actually, section 1.12A of the city's engineering design standards requires trip generation and distribution letters for all projects exceeding 200 trips per day or 50 peak hour trips. And for projects over 1,000 trips per day, a traffic analysis report, a TIA, is required with the scope to be determined by the city, number one, and for the purpose of determining potential traffic impacts that will need to be mitigated. But the very next paragraph, section 1.12B of the same standard states that Harvard Road mitigation is also an acceptable mitigation. So I think the intent is clear there. Again, the Valley alleged that the city of Liberty Lake was required to issue a certificate of concurrency before approving the project. And actually, I will point out that a concurrency certificate was not required for this project because City of Liberty Lake Development Code 104A2C2C, only requires a concurrency determination if a mitigation fee is not being utilized. Also, the issuance of a concurrency certificate is not relevant or timely at this stage of the project if they were not participating in Harvard Road mitigation fees, in that City of Liberty Lake Development Code 104AC2C4A states that a concurrency certificate shall only be issued upon payment of a mitigation fee, and mitigation fees are not due until building permit issuance. Regarding the Valley's allegation that that nowhere in the decision is there a finding of consistency with the Liberty Lake Comprehensive Plan, the RCW that they cited, 36.70B.040, actually requires a determination of consistency with the local government's development regulations. A finding of consistency with the comp plan is only required in the absence of applicable regulations. I also want to point out that the findings of fact and conclusions in the written decision document how the project is consistent with the development regulations. And I want to point out that development regulations are promulgated to codify aspirational goals and policies established in the city's adopted comprehensive plan. So ergo, if it's consistent with the development regulations, it's consistent with the comp plan. Finally, the Valley made an allegation that the decision was inconsistent with the City of Liberty Lake Comprehensive Plan regarding coordination with other cities. So first of all, relative to the project, we did coordinate with other cities and agencies, as is evidenced by the distribution list used for both the notice of application and the notice of decision. Secondly, the city does participate in regional transportation planning efforts through SRTC, and actually, we participate in several technical advisory committees in support of regional transportation planning efforts for both SRTC and STA. Also, the Valley has alleged that the decision does nothing to ensure that those public facilities and services necessary to support development shall adequately serve the development without decreasing service levels. And again, the Harvard Road mitigation analysis updated in 2014 and supported by our 2020 network analysis provided evidence that the fees were reasonably necessary and would mitigate the impacts of this project within the city of Liberty Lake. There was, and I want to point out that that 2020 network analysis actually had a particular focus on the Country Vista corridor because we knew developments were coming forward. And so we really emphasized that as a first blush look. And then we looked at the whole network secondarily. The Barker Road roundabout has already been constructed, and the Barker-Appleway intersection was adequately analyzed, evaluated, and planned for in the Valley's duly adopted transportation improvement program to address the potential impacts of this project. So no further mitigation was warranted. So in conclusion, the City of Liberty Lake respectfully requests that the HE uphold both the threshold determination and the SEPA review for this project and the city's written decision in the matter of neighborly development's preliminary binding site plan. And with that, I stand for questions.
All right, thank you, Ms. Key. I don't have any questions for you at this time. Mr. Hume, we did swear Ms. Key in as a witness, but that was mainly argument. So I guess my question would be, are you going to have follow-up questions for her now, or do we need to have cross-examination now?
I do not have any follow-up
Okay.
questions for her right now.
I assume that there's no questions from the others at this point. Or Mr. Harper, you have questions?
Actually, Mr. Examiner, I will want to question Ms. Key and.
Right. Are you going to call her as a witness, or do you want to question her now on
I
cross?
just soon do it now.
Okay, very good. Let's go ahead then.
Ms. Key, I'm not going to
Okay,
stand because
that's
the
fine.
way this is set up,
Right.
it's probably more appropriate to speak in the microphone. My name is Ken Harper, representing Spokane Valley in this matter. I want to ask you a few questions that I think will elucidate some issues that are already raised in your presentation. I just want to make sure the record is as clear on this as possible. If I understand your presentation correctly, and if I understand Liberty Lake's position correctly, the city of Liberty Lake has not adopted the South Barker Corridor impact fee promulgated by the city of Spokane Valley. I mean, there's nothing in Liberty Lake endorsing or supporting that South Barker Corridor impact fee study.
That is correct. In fact, we are on record as objecting to the methodology of that report.
Okay, so you haven't, it's not that you haven't only chosen to not adopt it, it's that you disagree with the basis of it.
That is correct.
Okay. And I think it's also your position that under WAC 197.11.660, any mitigation that you might require has to be reasonable and capable of being implemented. Or words to that effect. I mean, you're familiar with the regulations.
Yes, that is correct. That's exactly what it says.
Yeah. And since Liberty Lake has not adopted the South Barker Corridor impact fee methodology, your hands were tied. You couldn't impose that consistent with the WAC. Is that correct?
Yes, that is correct.
All right.
Except on a voluntary basis.
Okay, okay. So if that's the city of Liberty Lake's position on the South Barker Corridor impact fee study and WAC 197.11.660, am I correct also that it is the city of Liberty Lake's position that you had no ability to impose any mitigation on the Neighborly Ventures binding site plan at all?
No, please ask me that question again.
I'd be
because
happy to, yeah. If the city of Liberty Lake had the view that you couldn't use the South Barker Corridor impact fee study, okay? And you had to use any mitigation consistent with 197.11.660. You didn't have any basis to impose mitigation on the Neighborly Ventures binding site plan. other than the Harvard Road mitigation plan?
With respect to the alleged impacts on Barker Road, that is correct.
Okay, so, and Barker Road is in the city of Spokane Valley.
That's correct.
So the only Barker Road mitigation that Liberty Lake felt like it could impose was through the Harvard Road mitigation plan payment.
Or other as may be supported by adopted laws, regulations, et cetera. I would point out that the valley had not, at the time they made the comment, adopted impact fees for Liberty Lake.
I understand, but just so the record is clear, the only mitigation that Liberty Lake identified in the MDNS that in your view touches on anything germane to Barker Road is the Harvard Road mitigation plan payment.
I would not suggest that the Harvard Road mitigation fees were germane to Barker Road.
I agree with that, in fact. So let me ask you the question a different way. Was there any mitigation that the city of Liberty Lake required of the Neighborly Ventures binding site plan that provided any mitigation for the Barker Road corridor?
No, in part because the one intersection that was identified, Sprague Barker was already under, Sprague Barker was already under construction. The other one is planned for and reflected in transportation, the transportation improvement plan for the valley.
Does the MDNS analyze what you just stated?
It doesn't need to.
Does it though?
I'm not understanding the
Is there any
question.
text in the MDNS that correlates the absence of mitigation for the Barker Road corridor to what you just testified to?
No, but there's no requirement that be included in there.
Does anything in the MDNS discuss in any way the absence of impacts to the Barker Road corridor?
No, but I responded in an email to Mr. Clark's letter and explained exactly the basis for why we were not addressing that. And acknowledged that, as he had indicated, the city of Liberty, in his letter dated June 1st, the city of Liberty Lake had no ability to assign an impact fee unless we entered into an interlocal agreement, which we do not have.
Well, you understand, of course, that my questions aren't simply limited to impact fees. My question had to do with mitigation. All right. You understand the distinction?
I do.
Okay. You also asked the applicant to prepare, or the applicant, I guess, chose to prepare a TGDL, correct?
We actually required that they prepare
required
we required it. And in fact, one of the reasons why there was a delay in the issuance of the notice of application is because it did not adequately address the scope that we had laid out for it. And so what was sent out did address that scope.
A TGDL is a traffic generation.
Trip generation and
generation.
trip generation and distribution letter. I'm sorry, I just trip over it every time I say it.
Well, I get confused between that and traffic impact analysis, so I appreciate that. Did the TGDL provide any information on impacts of the project to the Barker Road corridor?
It did not, but the city of the valley was able to extrapolate the information contained in that trip generation and distribution letter to put forth their traffic engineer's opinion as to what the impacts might be. Of course, the analysis didn't take into account any of the pipeline projects that have already been approved in the city of the valley that are already causing that will already cause that intersection to fail.
And so you had that City of Spokane Valley perspective prior to issuing the MDNS.
I absolutely did. This isn't our first first dance.
Right. And so with that information, with the TGDL, just to sum up on this point, Liberty Lake established a sole mitigation measure for the Neighborly Ventures binding site plan, and that was payment into the Harvard Road mitigation plan.
That was not the sole mitigation. There were a number of other mitigating factors
I'm
in the
sorry.
MDNS.
With respect to traffic.
With respect to traffic, that's true.
You testified through your presentation a few moments ago about projects that will be funded by or are being funded by the Harvard Road mitigation plan or
Yes.
Harvard Road mitigation payment, if you will,
Yes.
correct?
Yes,
None of those impacts are in the South Barker Road corridor.
that is correct.
Because that's
It's
not in the
outside
city
of our,
limits. Right.
exactly.
I don't mean to talk over you this time. Okay. All right, very good. My next question then is, or my next couple of questions will be about do you call it the HRMP or do you call it the Harvard Road Mitigation Plan?
Others have referred to it as the HRMP, but we have way too many acronyms as it is.
All right, well, I don't want to get caught up in that. Our profession is full of acronyms. Okay, so with respect to the Harvard Road Mitigation Plan, I mean, I've read the document, the 2013 supplement, I've read your network analysis. So I'm trying to ask you more about just the overview of how these things work. Does the Harvard Road Mitigation Plan payment that Neighborly Ventures makes in this case, does that get earmarked for any particular intersection improvement, or does it go into a cumulative fund?
It goes into a fund that is for transportation improvements in our capital facilities plan and in our transportation improvement program that we adopt. And we adopt those every year. It's a 6-year plan. It identifies which specific projects funds are going towards from the Harvard Road Mitigation Plan. And those projects are identified based upon both that Harvard Road Mitigation Plan and that network analysis. The network analysis was done specifically to assess whether we were still adequately, the improvements that we were planning for were still adequate for our build out analysis as we know more as we proceed on forward. And it basically documented that we are on track. Again, master plan community. It's easy to do when you're talking about 6 square miles.
All right. So then, Ms. Key, if I understand what you just said correctly, and kind of branching off from what you said a little bit, if the Harvard Road Mitigation Plan provides cumulative funding for the TIP of the City of Liberty Lake, then
Not for all projects, only for capacity related projects. And that's an important distinction. It's only related to the capacity projects.
fair enough. And with respect to those, it provides that funding for those TIP projects as the City of Liberty Lake ranks those TIP projects in terms of their significance or their priority to the city as a whole. Is that correct?
It's not as based upon their priority to the city as a whole. It's based upon the priority based upon, and so that kind of gets reshuffled every year when we do the 6-year plan, based upon what's happening in real time in terms of development and where the impacts are occurring based upon development.
Right. Okay, good. That's helpful. So it could be throughout the city, throughout. the
Mr. Hearing
Harvard
examiner,
Road.
I'm going to object to the line of questioning that gets far away from what she testified to in the staff report.
I'm going to overrule the objection. Go ahead and proceed, although it is getting fairly far afield.
It'll link up, I think, Mr. Kim.
All right.
So Ms. Key, those funds could be spent, I mean, just to come to the point, those funds could be spent anywhere throughout the city if based on the sort of the TIP prioritization of other projects, other development needs.
Yes and no. We have an adopted 6-year plan, and guess what? We are working on improvements to Kramer Parkway. That's a big project. We have 6 million plus that we're contributing towards that extension in that roadway. It includes the signal at Kramer and Country Vista. This is a pretty significant improvement to create connectivity and disperse traffic on the Country Vista corridor where this project is located. We also are investing in traffic signals at Legacy Ridge. So we've got some pretty significant improvements that are in process or planned over the course of the next several years that are going to benefit, and they're the reason why this project doesn't have impacts.
The Harvard Road Mitigation Plan is it's a voluntary fund that developers may choose to pay into.
That is correct.
It's not generally applicable to every developer under every circumstance.
That is correct. It's voluntary. We have generally speaking, while developers choose to participate in that because it's a pretty cost-effective way and it's a pretty equitable way. We have had some developers that have chosen to go the route of a traffic impact analysis and pay their proportionate share for specifically identified impacts from their specific project.
And to just touch on your testimony right there, the Harbor Road mitigation plan could be paid into by a developer in lieu of preparing a TIA or a traffic impact analysis.
As is documented in our development code. This is a policy that has been established by the City of Liberty Lake City Council.
And the Harbor Road mitigation plan itself, I think we can agree, but you tell me if you disagree, that itself doesn't identify anything about where specific mitigation for specific projects is required.
Mr. Hearings, I'm going to renew the objection. I mean, the plan speaks for itself. The code speaks for itself. I don't think we need to dive into exactly the mechanics of how this works. It's far from her testimony on the staff report.
All right, well, I understand the objection about scope. I do. It was an overview presentation at the beginning. However, she was sworn in as a witness and Mr. Harper made the election to go ahead and do his questioning now as opposed to calling as a witness. I'm not going to try and create those kind of rails in an administrative process as opposed to a court direct versus cross. So I want him to go ahead and keep going. Plus, he's also alleged flaws with Harbor Road mitigation plan in his appeal. So please go ahead.
You understand my question? Do you need me to ask again?
Can you please repeat?
I sure can. The Harbor Road mitigation plan and payments into the Harbor Road mitigation plan, those themselves do not have any information value regarding where specific impacts of a project will occur.
I would not agree with that statement. And the reason why I say that, we look at the projects to see if they are consistent with our comprehensive plan and development code. We have done a build out analysis. So, and we just recently had a zone change go through where we required that they take a look at that because we wanted to determine if changing the zone would actually make this inconsistent with our build out analysis. It turned out that it did not, but so I disagree with that because those trips have been accounted for in our build out analysis, which looks at the uses that can go into various zones, et cetera.
On a cumulative basis, correct?
On a cumulative basis, yes.
Okay, no further questions.
All right, thank you, Mr. Harper. Mr. Hume, do you have follow-up questions?
I do, just a couple, thank you. Ms. Key, in your role as the responsible official under SEPA, you have an obligation to consider various environmental consider documents that you have available to you related to environmental impacts. Is that correct?
That is correct.
And can you tell us what, and there's some listed in the staff report, excuse me, page 17 of our brief also pulls this out, so I don't need to be redundant here. But can you, either by looking at their staff report or to the best of your recollection, tell us what you looked at when considering whether or not mitigation was appropriate on the intersections inside the city of Spokane Valley?
Yes, I can. So there were three criteria that I think that really, and it all comes from WAC 197.11.660. The first of which is those mitigations have to be adopted. Now again, the Liberty Lake, the impact fees, the South Barker Road impact fees for Liberty Lake had not been adopted. In fact, I literally, the day after the comment period closed, I got a letter from Mr. Clark stating that the Valley was going to be considering that, adopting that at a June 14th special meeting, day before our appeal period closed. That's number one. And it certainly hadn't been adopted by Liberty Lake, who actually has the substantive authority in this particular case. Liberty Lake City Council did not adopt the South Barker, not because it wasn't considered, but because we had major objections that have been with the methodology. So that's number one. It hasn't been adopted. So I don't have the ability to impose that. That's number one. Number two, is without an adopted impact fee and without the ability to, without an interlocal agreement to collect and convey such impact fees, I have no ability to enforce it. So it's neither reasonable nor is it possible.
Let me ask you specifically about documents that you may have had an opportunity to review. And I'm just going to read you this list. Again, it comes from the staff report, and you can just confirm for me that these are documents that you did take a look at. You did consider information from the city of Spokane Valley. You did consider city of Spokane Valley comments from Jeremy Clark dated 5/31.
Yes.
I'm just gonna read through the list and then city of Spokane Valley comments from Jeremy Clark dated 6/1/2022.
Yes.
City of Liberty Lake response from Lisa Key dated 6/2/2022.
Yes.
The SEPA checklist,
Yes.
the trip generation letter dated April 18, 2022.
Yes.
The updated trip generation letter dated May 3rd, 2022.
Yes.
The South Parker Corridor impact fee cost per trip segment analysis.
Yes.
The South Parker Corridor transportation fee impact rate study for Liberty Lake.
Yes.
The Spokane Valley 2023 to 2028 6-year transportation improvement
Yes.
plan. The City of Liberty Lake engineering and design standards.
Yes.
The City of Liberty Lake network analysis corridor study update.
Yes.
The City of Liberty Lake 6-year capital facilities plan.
Yes.
The Harvard Road mitigation plan 2013 update.
Yes. Which was actually adopted in 2014.
Okay. I have one other question for you. And this relates to the Harvard Road mitigation plan. What studies, what forms the background of the Harvard Road mitigation plan? What sort of background studies or analysis work was done to then move the city to codify that impact fee plan?
So I believe one of the authors of that is sitting in the room, may be able to give you, because Mr. Whipple is actually an expert in the area of transportation planning. I'm just a lowly planner who maybe understands a little transportation planning.
I'm just a simple country lawyer who barely understands any of that.
But we
All right,
basically.
modesty aside, go ahead and give it a shot.
Basically, what we do is we look at a build out analysis and honestly, the base for the analysis goes back to SRTC's transportation model, but we also have to, we refine the model to add in local roads and intersections. We do additional transportation counts. We then look at what has been built in the city to date, and we also project for the network analysis that we did to verify that what had been planned in the Harvard Road mitigation fee was still relevant. We actually focused on a 6-year growth anticipated on the Country Vista corridor. And then we looked at a full build out analysis for the entire city because the Country Vista corridor is a hot growth area for the city. And so we looked at that. We took trip counts. We looked at, and when I say we, my consultant Parametrics did this analysis and created a updated model to look at what the impacts of development was going to be. Where were the areas where we had level of service challenges, and what were the mitigations that we were going to use. In some cases, we looked at signals. In other cases, we looked at roundabouts, and we gave consideration to what we needed for the full build out. Where, as an example, we looked at a roundabout on Country Vista and Kramer Parkway. However, that wouldn't take us to our full build out with a single lane. We'd have to go to a double lane, and we had great concerns about doing a double lane on a corridor with that kind of volume. So we chose to go with the signal instead. So we actually not only identified where the level of service concerns were at, but what the appropriate mitigation was. And And that then gets funneled into our 6-year transportation improvement program.
And the Harvard Road mitigation plan, the catch area for that is the corporate limits of the city of Liberty Lake.
Yes,
that
it
correct?
was, yeah, so in 2014, when it was originally done, it was actually done as part of the incorporated county and, or the unincorporated county. The city of Liberty Lake incorporated, but then there were several annexations. In one of the reasons for the 2014 update was to expand the area to include the corporate boundaries. So that happened in 2013, 2014.
Do you off the top of your head know the approximate size of the corporate boundaries?
Prior to, no.
No, now.
Oh, it's a little bit over, it's a little bit over 6 square, it's like 6.35 square miles, something like that.
You also have experience as the planning director in the city of Spokane, is that correct?
That is correct.
And what years were you there?
I was there from 2015 to 2018.
And the city of Spokane has traffic impact fee ordinances, is that correct?
Yes, they do.
And how big are those, the boundaries of those districts?
Significantly bigger than our little small city.
Thank you. No further questions.
All right, Mr. Smith, do you have any questions?
No questions. Thank you.
All right. All right, then let's go ahead and move on. And thank you, Ms.
Thank you.
Key. So we've done the presentation by Ms. Key as the overview, and we've obviously had questioning done also. Let's go ahead and move on then to presentation by the city of Spokane Valley as the appellant, Mr. Harper.
Thank you, Mr. Xander. In your opening comments or your opening proceedings. you
Yeah.
suggested that each of the parties would make sort of introductory comments or opening statement. I question whether that's reasonable.
We don't need that now, it would seem.
Let's call it first.
Yeah, let's go ahead and,
Okay.
yep.
Spokane Valley, call Vickerson.
Morning, Victor
All
Salem,
right.
Transportation.
Can you raise your right
Solutions.
hand, please? Do you swear from the testimony you're about to give will be the truth?
I do.
All right,
Okay, Mr. Salem, what I'd like you to do, if you will, is just provide an overview of who you are, what your background is. So I'm not gonna do a narrative, or I'm not gonna do a Q&A with you. You can just provide that as for the narrative testimony of the examiner and look at that.
yeah, that's fine. Just one quick question. You moved your microphone off the table. Are we getting this on the recording adequately? His voice carries fine in the room, but I just want to know.
It won't pick up in the recording if he's not talking into the.
All right, can you put the, please, yeah.
All right, I can say that again. Mr. Salem, if you will, just introduce yourself and if you would provide a little bit of background on your credentials and what you've been asked to do by City of Spokane Valley in this matter.
Good morning, Mr. Xander.
Morning.
My name is Victor Salem. I'm the president of Transportation Solutions Incorporated. We're a civil engineering firm specializing in traffic engineering and transportation planning. I'm a licensed professional engineer in Washington and Alaska. I have about going on 40 years experience. Participated in preparation of numerous transportation impact analyses, as well as transportation elements prepared under the GMA requirements for the state of Washington. The city of Spokane Valley requested that I provide an independent review of the trip generation memo and provide an independent analysis of the potential impacts of the Neighborly Ventures project to transportation facilities within the city of Spokane Valley.
Okay, Mr. Salem, so you had a chance to prepare, what would you describe actually your work product in this matter? I just want to make sure I'm using the right terminology.
Yeah, we describe as a technical memorandum, an abbreviated traffic impact analysis, again, to try to identify potential probable impacts that may be occurring as a result of this Neighborly Ventures project in Spokane Valley.
That's your document dated August 18, 2022.
Correct.
And we're calling that a technical memorandum? Is that what we're calling it?
That's my understanding.
Okay,
Right.
thank you.
So let's talk about that just a little bit more before you give an overview of what you found in your technical memorandum. What is a TGDL in your understanding?
Yeah, it's a trip generation and distribution letter. I get the acronym mixed up too. It's just a stumbling block. What it does is describe trip generation. So the amount of traffic generated by a proposed project for both the AM peak, PM peak, and daily. It estimates the traffic going into and out of the development. So that's the trip generation, how many trips. The trip distribution piece of that letter is where do those trips go? Where do they originate? They originate from the development and exit, go to other locations, or they're coming from other locations and ending up in the development. So that's the distribution, the where, the generation is how many.
Can you contrast that with a TIA or a traffic impact analysis?
Sure. So a traffic impact analysis would then follow those trips. So the trip distribution would then assign those trips to various roadways and intersections around the site. Generally, there's a threshold number, say 10 PM peak hour trips. And so you follow those trips along the roadway network as they leave the site and head towards other destinations and other facilities. And then you'd analyze the before and after traffic conditions at each of those facilities that are impacted by that threshold amount of traffic.
If I understand correctly, your technical memo is not actually a TGDL or a TIA. Is that right?
Correct.
Okay, what's the similarity between what you did in your technical memo and let's say a TIA, if there's any similarity?
Sure. What we did is we took the next step, moving towards the TIA and looking at what intersections specifically in the city of Spokane Valley would likely be impacted by this Neighborly Ventures project. We checked the distribution prepared by the applicant. We also did an independent trip distribution, looking at some other data science that we were able to acquire that actually tracks real vehicle movements and came up with really the similar distribution. And what caught our attention was the trip generation and distribution letter. And our analysis shows that about 50% of the traffic generated by this site is destined into and out of the city of Spokane Valley. So it leaves City of Liberty Lake, and primarily impacts the intersections of Barker Sprague and Barker Appleway, as we've discussed.
Okay, I want to hear more about that, but I want to back you up for just a second here. Your testimony in response to my last question began with the statement that we took the next step. You took the next step beyond what?
So beyond identifying just where the traffic went in general, 50% went towards Spokane Valley, to looking at what facilities would that impact and how would they use it.
Do you mean to say that you took the next step beyond the TGDL?
Correct.
Got it. Okay. Now then, if you perform your technical memo as something beyond the next step of the TGDL, was your technical memo nevertheless something short of a full TIA?
Yes, we again wanted to look for probable impacts to establish that first case versus doing a full TIA.
Were you focusing, and you've already said this, I just want to make sure it's clear. You were focusing your study on a particular area.
Correct, the city of Spokane Valley. If we were doing a full TIA, we would have looked at City of Liberty Lake and all their facilities as well, followed every trip out from the site.
All right. So now, if you would, Mr. Sailman, tell us a little about the significance of what you found on the study area that was identified in your technical memo.
Yeah, so what we found is that the project trips would impact two intersections. We've mentioned them several times, Barker Sprague and Barker Appleway. In particular, at Barker Appleway, in our analysis, we found that the trips would essentially trip the level of service threshold from level of service D to E. We also found and suggested that that responsibility for their project would be a proportionate share, that recognizing other projects were going to have impacts at that intersection. So we looked at using, again, that 50% distribution. We found about 144 project trips would use the intersection, with a total of about 2,900 total intersection trips, suggesting that their proportional share of that intersection improvement would be about 5.7%.
I want to pause you on that, Mr. Sailman. I don't want you to make a mistake as to number. I think in your memo, you identified the project trips as a percentage of 5.27.
Oh, sorry, 5.27.
Okay, all right.
Yeah.
All right.
Yeah, 2,734 trips through the intersection without the project was our 2022 estimate, and 144 estimated project generated trips.
You've testified already to the total, or times not to the total, but to the percentage of trips that will be generated in the direction of South Barker. What was that percentage again?
It's about 50%.
How many trips? Let's talk in terms of absolute numbers. How many ADTs do you project, or does even the TGDL project from the application to the city of Spokane Valley Barker corridor?
Here. Yeah, so our independent analysis is very similar to what the TGDL letter was. We estimated 3,306 trips, total ADT generated by the project, 400 AM peak hour trips, 291 PM peak hour trips. And then our project trip distribution. Just so I get the number right. Yeah, I'm not seeing the exact number. It is roughly that 50%. Trying to find the exact paragraph.
You think it's in the neighborhood of 50%, Mr. Selman?
Yes.
Okay, I think we can move on from there. You testified earlier regarding the project trips as a percentage of trips through the Barker Road and Appleway Avenue intersection. Did you also reach a conclusion regarding Barker and Sprague?
Yes, at Barker and Sprague, it was about, our estimate was 1.53%, smaller percentage.
1.53?
Correct.
Okay. Now, what I'd like to do, Mr. Salmon, is provide some characterization of that. I mean, if we're talking about 3,000 ADTs and then we make that pertinent in terms of the PM peak hour at 144 project trips, what's the practical significance of that for the experience of someone at that intersection?
So every intersection responds to every different trip differently. Through trips and left turning volumes are the key issues that typically affect intersection of level of service. When we have left turning vehicles conflicting with through trips, we increase intersection delay significantly. We use a program called Synchro that uses the highway capacity manual methodology for intersection level of service, which is based on driver delay, essentially average delay and movement delay at those intersections. And our analysis showed that adding those additional 144 trips would increase the level of service delay beyond the threshold of D, which is the city of Spokane Valley standard.
So it increased the delay. Is that another way of saying that the level of service would drop?
Yes.
Right.
Yeah, increase
It's the
delays.
inverse, isn't it? Yeah. Okay, I can follow that. In terms of projects that you review, is the need to make an assessment of this number of trips on an intersection, is that a fine-grained analysis, or is that a significant load of traffic through the intersection? Can you help a layperson understand that relationship?
Yeah, in my experience, agencies typically require, when we do a full TIA, traffic impact analysis, that we essentially follow those trips to about the 10 PM peak hour trips. Sometimes it's 20. That represents more like 100 ADT or 200 ADT. In this case, 144 trips impacting a single intersection is typically something we would analyze always. Over 100 new PM peak hour trips or a 5% increase in traffic at a single location is something that would be considered in a TIA.
Does a jurisdiction like Spokane Valley or really any jurisdiction expect a growth in traffic at any particular intersection? Is that a common industry expectation?
Yeah, most in terms of assuming some background growth in addition to trips generated, annual growth rates on the order of 1 to 2% to 3 or 4, even in high growth areas, are often considered. So we would take a traffic count. If we assume the development would have an impact a year later, we would add 2%, and that would be the combined, growth of all the rest of that jurisdiction over a year.
So what's the significance in terms of the background growth of this project adding 5% of the project trips through that intersection?
Yeah, it's the equivalent of multiple years of what we typically would assume as background growth.
Now let's talk about background effects in another respect, Mr. Salmon. Are you aware of other projects that have been approved and are in process that affect the Barker corridor?
Yeah, we did not have that information when we prepared our analysis, but I have reviewed the response letter from Whipple Engineering that identified 5 background projects that they suggested we would have included. And it's interesting that those 5 City of Spokane Valley projects that would have been in the background, according to their estimate, was 121 total trips. This project in itself was going to add 144 additional trips to the intersection. So the equivalent of 5 other City of Spokane Valley trips, projects that will be occurring at that location.
Mr. Whipple also points out another, I guess just we'll call it a project in the vicinity of Barker and Apple Way, I think it is. Are you familiar with the Starbucks going in at Barker and Apple Way?
Just only to the extent that it's shown on the diagram as a possible project.
As a possible project, fair enough. Mr. Salmon, have you ever had an opportunity to study a Starbucks before?
Yes.
Yeah. Well, is there any kind of characteristic that you can attribute to trips that a Starbucks generates?
Yeah, Starbucks have a very high proportion of what we call pass-by trips. In general, people don't make a destination trip to a Starbucks. You're on that road, you're driving in and out. It's not generating a lot of new traffic. Their intent is to feed off traffic that's already on an arterial. That's why you'll often see them on both sides of the street. They don't even expect a customer to make a left turn to enter their facility. So it's primarily pass-by trips that are going in and out. So we don't typically assume a lot of what we call new traffic associated with that kind of a facility.
Okay, Mr. Salmon, a couple other questions, and I think I'll be done with you. The city has a project that's been completed now at Barker and Sprague. Are you familiar with that? Yes. What is that project?
They improved the intersection and built a roundabout.
Right. Was that intersection improved and operational? Well, I shouldn't say that's a compound question. Was that intersection operational at the time this application came into your knowledge?
No.
Is that something that's occurred since this has been pending?
Yes.
Are you aware of a particular project that the city of Spokane Valley has planned for Barker and Apple Way?
Yes.
What's that project supposed to be?
It's widening the north leg of the intersection from Apple Way up to the interchange.
Is there any way that you can explain, Mr. Salmon, how the what can we call it? I mean, does that project have a name?
I don't remember it. I referenced it in our report. Let me see.
Widening of the southbound approach to Barker. Is that a fair way to describe it?
Sure.
Okay. Is there any way that you can describe or explain the relationship of widening the southbound approach to Barker to the kinds of trips that you think will be generated by this binding site plan at that intersection?
Sure. This project adds through traffic, east-west through traffic to the intersection and a significant number of southbound left turns. By widening any approach to a signalized intersection, you create the opportunity to redistribute the green time. The delay at a signalized intersection is directly proportional to how much green time each movement gets. So some drivers will experience more delay, some less, depending if the green time isn't signed properly. So adding a right turn lane, for instance, takes right turn movements out of the through movements, lets more vehicles go. So we can actually increase the green time for a critical movement like a left turn by adding through capacity, even adding through capacity in an opposite direction. So that more green is available for the left turns, less green is necessary for those other movements. So we don't necessarily have to improve the exact movement where we're adding traffic. We can improve another movement, which that then gives us green time for the critical movement.
So that improvement of the southbound approach to Barker has a beneficial effect that you think would supply mitigation to the trips being generated by the binding site plan project?
Correct. Our synchro analysis demonstrated that it provides improvements.
Okay. I have no further questions here. Thank you, sir.
Just one quick thing,
Yeah.
green time, does that mean just minimal delay or does it mean something more significant?
So yeah, when you're at a traffic signal, when the signal turns green for you, it might stay green for 3 seconds or 15 or 30. And so that proportion needs to be proportional to how much traffic is in your lane. If it's not green long enough and you're that last car, it turns red, you're now going to be delayed a whole cycle length until it comes around again to serve you. So we try to not have that happen. When that starts happening for more and more vehicles, the delay at the intersection goes up, and that's considered what we consider a bad operation or a failing level of service.
Understood. Thank you, sir. Mr. Smith or Mr. Hume, who wants to? Okay, Mr. Hume, would you like to go for it? No questions from you? All right, Mr. Smith.
Just briefly, Mr. Salem, thank you. Good afternoon or good morning, excuse me, Nathan Smith.
Good morning.
Here on behalf of the applicant I've got a copy of your report in front of me. Is it your testimony today that your report did not consider background projects?
Yes,
So your project did not consider any of the projects identified in Mr. Whipple's report?
yes,
If your report contained those background projects, would it change the participation percentage for the project?
yes,
So would that increase or decrease the percentage participation?
decrease,
Sorry, what was the answer?
decrease.
Thank you.
I also it sounds to me, I just wanted to confirm. Are you aware that the roundabout has been completed at
Yes,
Barker and Sprague?
Yes, sir.
Okay. Does the Neighborly Ventures project cause the roundabout to fail?
no,
And just finally, is there any sort of interlocal agreement between Liberty Lake or the city of Spokane Valley?
not that I'm aware of.
Thank you. I have nothing further.
Mr. Harper.
Yeah, I have a redirect on that. Mr. Salmon, Mr. Whipple's response to your technical memo, that's his response dated September 6, 2022. It describes a series of background projects. We've talked about that a little bit already. You're familiar with that?
Yes,
Are you familiar with whether or not any of these background projects, either separately or collectively, would change a level of service at any of the intersections you studied?
I've not seen an analysis to tell me that, and I did not create one.
So we don't know if any of these independently or collectively would have the same effect that you were able to demonstrate that the Neighborly Ventures Mining Site Plan has on those intersections.
I do not know that.
Nothing further. Thank you.
All right, thank you, Mr. Salmon.
Thank you.
Any other witnesses?
We have no other witnesses, Mr. Examiner. Thank you.
All right, very good. Do you wish to present argument at this point, or do you want to reserve that for after witnesses are
reserve.
called? Okay. Since we're doing this, we're sort of playing this by ear. All right, let's see. All right, then the next up, now I'm forgetting the order because I had it all set. Is it going to be the applicant next?
Mr. McGinn, I think it was our turn, but we take just a short break.
Yeah, we can, sure. How long do we need? You want to see some prep time or
Maybe
just a quick break?
Just a quick break. Everybody to
Let's see what
take
we
a
got
lap.
here. Okay, you want to start up again at 10:30?
That sounds great. Thank you.
All right, we'll take a break till 10:30. Thank you.
That is. So, yes, they're. Yes.
Yeah, you know, perspective. All right, it's 10:30. Everybody get situated, so we get started again. Mr. Hume, are we waiting on the gentleman? Okay,
Mr. Examiner, I've got just a procedural question that I can probably raise without stepping anybody's toes.
Sure.
If Mr. Selman is done, can he be excused?
if everybody's good with that, that's fine.
I'm good with that.
All right,
Okay.
all right.
Great.
Thank you, Mr. Salomon.
Thanks, Vic.
You mind?
All right, let's go ahead and get started. We're at this point, then it's time for the presentation, witnesses and evidence by the applicant, Mr. Smith.
Good morning. Our first witness on this matter is Mr. Todd Whipple.
Please raise your right hand. You swear from the testimony you're about to give will be the truth. All right, thank you, sir.
So, Mr. Whipple, would you give us a brief summary of your experience and background?
Licensed engineer in the state of Washington. Is that loud enough?
Just move it a little closer, please. Thank you. Yeah.
Licensed engineer in the state of Washington.
That's not working.
It may not be
I
on.
don't believe that mic is on.
Green.
Is that better?
There you go.
You getting it now?
You have to kind of really talk into it.
I'm not a radio star. I don't know how this
You're
works.
good. You're good now. I just want to
Okay.
make sure it's getting recorded because I can hear you fine without it.
Okay. I'm a licensed engineer. My name is Todd Whipple. I'm a licensed engineer in the state of Washington. I'm president of Whipple Consulting Engineers. Over the years, well, my specialties are transportation and drainage. I know they don't go together, and we're not talking about drainage today, so we're going to stick with transportation. Over the years, I've probably worked on more than 1,000, less than 3,000 traffic studies of different sizes and scopes. I've worked on traffic studies from everything from the size of the naval home port relocation in Puget Sound to a coffee stand. So kind of ran the gambit over the years and over the different things. I have almost 40 years of experience, know quite a bit about traffic. I think I'm considered an expert in the field. And I don't know, I have a hard time talking about myself. So is that enough?
That's good, Mr. Whipple. Thanks. Would you describe what your work has been on the Neighborly Ventures project?
On the Neighborly Ventures project, we were hired to prepare a binding site plan application with the city of City of Liberty Lake, I apologize. And that was going to be a mixed use project comprised of commercial and residential uses. We prepared the entire application package, including a trip generation letter and a SEPA checklist, and submitted that to the city of Liberty Lake. And went through the process working with the city of Liberty Lake to take that project through to fruition, which would be a approved binding site plan and ultimately a final BSP. And then we'll be the consulting civil engineers on the Neighborly Stanley Apartments project.
As part of the application, you said that there was a trip distribution and generation letter, or trip generation and distribution letter prepared. Why was that prepared?
Part of the City of Liberty Lake code requires that if you have a project that's going to generate a certain amount of trips, that you're required to submit a trip generation and distribution letter with your SEPA checklist. And so we complied with that requirement and submitted it.
What's the alternative to preparing a TGDL?
Well, in the City of Liberty Lake, there is no requirement. You have to submit a trip generation distribution letter at application with a SEPA checklist.
Yeah. What does that TGDL get you?
What the trip generation distribution letter gets you is it allows the City of Liberty Lake or any jurisdiction to review your SEPA checklist. I think specifically section 14 of the SEPA checklist, where we dive into transportation issues. It allows them to make a decision as it relates to the environment based on not only their code, but WAC 19711 as to impacts and potential mitigation. And so it's a requirement that you have to fulfill. And based on that, then the city, and any jurisdiction, either within their code or without of their code, makes a determination based on the trip generation letter. Either you need to follow that with a full traffic study, or there are other means that you can achieve an end goal as you move through the SEPA process.
So as to this project, what was that end goal?
The end goal was an MDNS, so that the project could move forward. The City of Liberty Lake gives you an option, much like other jurisdictions do, of either moving on to a traffic study if you think they give you two options: do a traffic study or accept the Harvard Road Mitigation Plan impact fee requirement. And having done traffic studies for a long time, we have always found that they are not necessarily the best way to spend a project's time. They cost time, they cost money, and mostly there's a delay issue associated with it. So anytime anytime there's an impact fee, we'll always recommend to our client, take the impact fee and pass on the traffic study. You'll pick up between 1 and 5 or 6 months, or in the case of the DOT, 3 years. And so, and you're able to move forward. So in this instance, when we got through SEPA review and the city asked us, do you want to do a traffic study or accept the Harvard Road Mitigation impact fee, we recommended to our client to take the Harvard Road Mitigation fee and move forward and keep the project on step and on time.
So Liberty Lake said, you've done everything you need to do under SEPA for traffic purposes.
Correct.
Okay. And were you involved? We had some testimony from Ms. Key earlier about correspondence received from the city of Spokane Valley dated June 1 and May 31 of this year. Were you involved in taking a look at those?
Correct. So
those letters?
When an application receives a comment from either a jurisdiction or a concerned citizen, most jurisdictions pass those on to the applicant for response. In this instance, we were aware of what the city of Spokane Valley's request was. And being familiar with the Barker Road Corridor Study, we looked at the Barker Road Corridor Study. At that time, I wasn't even aware there was a fear and peer letter coming. Looked at the Barker Road Corridor Study as adopted by the City of Spokane Valley City Council. Looked at where our location of our project was. Looked at figures 22, 23, and 25 in the Barker Road Corridor Study. Under figure 25 of the Barker Road Corridor Study, it says that all projects south of Appleway pay no fee. So based on that, I think we wrote a pertinent response back saying, well, we don't have anything to do in the Barker Road Corridor Study. I think it was a great response from Jeremy, but unfortunately, there's nothing for us to do. We're not going to pay a $0 voluntary impact fee. So there's no reason to voluntarily pay a $0 impact fee. So we just assumed that it was a kind of a form letter he writes to all projects in the city of Liberty Lake that he believes are in the boundary of his Barker Road Corridor Study, and we moved on.
I just want to unpack that just a little bit, because I think there's two fear and peers studies, right? Just to make sure, there's the South Barker Road Corridor Study
Is a fear and peer study.
is a
correct?
fear, and then there's the South Barker Corridor Transportation Impact Fee Rate Study for Liberty Lake.
Correct. There was the second one that we weren't aware of. We hadn't seen it at that.
So
point.
that, at the time Neighborly was processing his application, that study wasn't adopted.
No,
Okay, so when the application was in process, the only document that you were aware of as being adopted was the South Barker Corridor Study.
yes,
And that, in the South Barker Corridor Study, is where figure 25 is.
correct.
Okay, and figure 25 says,
$0 impact if your project is south of Appleway,
and this project is south of Appleway.
south of Appleway.
Okay. Have you had a chance to review Mr. Salmon's letter? That
Yes.
was submitted by Spokane Valley. Okay. And in connection with that, you prepared a response, sort of.
Oh,
comment.
kind of a review, kind of a critique, kind of a response, whatever
Okay.
you want to,
Sure.
nomenclature you want to put onto
Sure.
it.
Just give me a second. We have too much paper. Can you, and I've just got a copy. It's your September 6th, 2022 letter that's submitted as part of the record. Can you describe your experience with the Harvard Road Mitigation Plan?
Oh, gosh. Well, this goes all the way back to the county days. So, back in 1995 or 1997, whichever year it was, the county was Meadowwood was continuing to develop at a incredible rate back in those days. We were going through a kind of a preliminary plat process, and the county was going through either a comp plan process or some other process at that time. And so we wound up having to go through a series of environmental reviews, and the Department of Transportation weighed in. And in 1995 or 1997, the DOT hadn't done their widening of I-90 east or west of Argonne yet. And so they proclaimed that I-90 was closed to commuter traffic. And so we're all sitting there going, wow, that's crazy. And so the two engineering companies that were involved was Inland Pacific Engineering Company, which I was a president of that company, and Taylor at that time. And there were 3 traffic engineers involved in all the various projects that were going on in what became the city of Liberty Lake. Jim Borgen, who was a licensed engineer, is now deceased. Well, actually, he wasn't a licensed engineer. He was a modeler. And then Ann Winkler at Inland Pacific and myself. And so along with Pat Harper at the county, we decided we would use this new state law that allowed us to create a transportation benefit district. And it turned out to be the Harvard Road Mitigation Plan. And the reason that it was created is because it was the impacts from the state closing, for all intents and purposes, closing I-90, was that the city of Liberty Lake, which became the city of Liberty Lake at that time, had very few opportunities for ingress and egress from the city and to allow the city to continue to grow. So it was decided amongst all the developers, the pertinent developers at the time, the engineers and county officials, that they needed to create a transportation benefit district to mostly build Country Vista Boulevard to Appleway. The county did a county project to build Appleway so far, and then the Country Vista. The Harvard Road mitigation funds went to kind of connect the rest of it. And it's for those of us that remember. From Liberty Lake Drive. To Appleway, sorry. To Barker, there was really nothing. There was no development. And there was really, there was no real road. So Taylor, I think, designed the road and it got built and allowed the city of Liberty Lake eventually to incorporate and become a city. And then as it relates to the mitigation plan, I know parametrics, which is the Taylor Engineering, continued on working for the city and continued on updating the Harbor Road mitigation plan. And we've reviewed the plan and have worked inside the plan and understood it for however long that is, 35 years, I guess, or 37. Well, a long time. I'm not going to do the math anyway. And so we always will say our position on impact fees versus traffic study is always take an impact fee. And so we had no problem, mostly because we're intimately familiar with the Harbor Road mitigation plan and accepting the Harbor Road mitigation plan as mitigation for this project.
Sure. And so the idea is that here and as in other projects, the mitigation is directly related to the impacts of the project that you're paying.
I think that's the presumption, I think, for impact fees is generally that, yes, whether it's specific or not, sometimes it's hard based on like the network analysis or any other analysis associated with impact fees. There is always some generalization of the fee. You have to do that. You have to say, okay, well, we want to build these 9 things and you're going to go do a taco stand over here. Not sure your taco stand is going to impact all these 9 things, but you're inside this area where all trips impact these 9 things. Therefore, you will participate.
And then the calculation of the fee is based upon the number of trips from your specific project.
Correct.
Okay. Just want to also kind of looking at your letter, also want to just have you discuss generally what Mr. Saleman's letter might, have given you some concern in your professional analysis of traffic impacts.
I think at the end of the day, traffic engineers are traffic engineers, and we 92% of the time see everything the same way. It really comes down to distribution. I know when we submit a trip generation letter to various agencies, we have things that we take into consideration when we do the trip generation letter, and you send it to the agency, and the agency has some knowledge that you aren't aware of, and they say, oh, well, you had 22% of your trips going this way. This thing's going to happen. So it's probably, you shouldn't have that many trips go that way. We would prefer you redistribute some trips a different way. It's as much common knowledge, anecdotal information, and traffic counts that vary up to 10% a day. You put all this in the mixing pot and you come up with your trip generation information, and the agency accepts it, modifies it, or asks you to completely redo it and start over. And so in this instance, our trip generation letter was accepted by the city of Liberty Lake and moved on.
Yeah.
Correct.
And I guess it's as specific to the TSI letter, there was no consideration of background trips.
Oh, if you want to go to, yeah. So Victor qualified his memo. It says it on the cover that it's a technical memorandum. Much like so many different things, everybody has a different definition. When we reviewed a technical memorandum, we reviewed it as if they were doing a traffic study for this development, and that it would follow the city of Spokane Valley's traffic study requirements. We didn't understand until he testified today that it was just kind of a quick peek. I think there was a question that was asked about, had the TSI analysis included all of the background projects, whether it was 1 trip or 1,000 trips, would that have changed the percent participation? And I think his answer was yes, it would have. None of us really know what that answer is because there was never a full traffic study done to load all these intersections up with all these background trips. So how we do a traffic study is you do existing counts, you take all your background trips, they go on first because they're approved, whether they've paid their fee or not, they still represent cars on the system. Then you put your cars on the system. And then you get your ultimate level of service with your background trips and with your project. And it's only when you go through all that effort can you really determine an appropriate impact or percentage to any one intersection.
So
And so he kind of went halfway there and didn't go all the way there.
Yeah, so if those background projects were considered, it may change the perception of the impacts of this project.
Correct. Might have already been level of service when we got there. All these projects were approved in 4 of us. It wouldn't have been level of service D. It might have been level of service F. Could have been level of service F, what we call plus plus. It doesn't really matter. It could have changed the percent participation from his 5.27 to 5.26 or 1.69. We don't really know because that level of analysis was never completed.
And it's not required by the city of Spokane Valley, or excuse me, City of Liberty Lake Code to do that.
Correct. No.
Mr. Whipple, do you do work in the city of Spokane Valley?
We do.
And then do you process projects and prepare transportation, trip generation letters?
We do.
Are there periods of time in which sometimes Spokane Valley asks for a fee in lieu of traffic impact analysis?
There is in the Barker Road corridor study, when you submit your trip generation distribution letter, you have an option of paying the impact fee or doing a traffic study to determine if your impact is really less or greater than your impact fee. And we generally, not always, generally, it depends on our client, recommend that they take the impact fee. It's just quicker and moves the process
Sure.
along.
So it's the same process that the city of Liberty Lake uses.
Yeah,
just
same
in the city of
process, yeah.
Spokane Valley. Okay. I don't have any further questions for you,
Okay.
Mr. Whipple.
All right, thank you. Mr. Harper?
No questions.
Mr. Hume? All right, Mr. Smith, anybody else you want to call today?
We just wanted to put Mr. Brian Moore briefly as the representative of the applicant on.
All right. Raise your right hand. Do you swear from the testimony you give will be the truth?
Yes,
Thank you, sir.
And I just asked Mr. Moore, he's the representative, to introduce himself and then describe a little bit about his the project and his company.
sure. Mr. Hearings Examiner, my name is Brian Moore. I'll actually add a little clarity because I've seen both Neighborly Development and Neighborly Ventures today. A little clarity about that. I am the CEO and owner of Neighborly Ventures, and Neighborly Ventures is the sole member of Neighborly Development LLC. We have 3 subsidiaries: development, construction, and property management of multifamily housing predominantly, but not exclusively.
But the applicant is Neighborly Development LLC, correct?
I think the
correct.
applicant is technically
Okay.
Neighborly Development LLC, but
All right.
I've heard a lot of Neighborly Ventures today, so I just wanted to clarify. We're headquartered in Salem, Oregon, doing work in Washington, Oregon, Idaho, and Utah. Our name is very intentional to reflect our sincere desire to do everything we do in a neighborly way. To that end, we hope to build this community, as we do with all of our communities, a community that provides market rate multifamily housing. Will not only be the developer of this property, but will also be the property manager when it's done and part owner. We want our residents to be good neighbors to one another, and we want to be a good neighbor in the community where we build and operate. What does it mean to us to be a good neighbor? It means for us to understand, at least to our best ability, and be responsive to the needs of desires of others. And certainly that extends to the cities of both Liberty Lake and Spokane Valley. We recognize that although we're not intimately familiar with everything that these 2 jurisdictions do, we believe that both jurisdictions are seeking to do good for their communities and their residents. We also acknowledge the conflict that is being borne out here that seems to have existed before us. And we hope that they can find alignment. And we're happy to do our reasonable part in trying to help facilitate that, maybe even. And I personally will just say I like the idea always. It's consistent with our philosophy that when two parties may potentially impact one another, that they get in the room and they talk about it and see if they can work that out. Unfortunately, in this case, our challenge is that we're ready to perform on what has been asked of us and what we understand to have been the requirements for doing our development at this location, but we're stuck. We can't proceed and to do the development itself or make the payments or improvements that are required of us. And that has significant, I'm confident most everybody in the room can understand, that has significant economic impacts for us, particularly in the climate we're in, where construction costs have already been a huge issue, and now interest rates are compounding that issue. And we're not seeing, we're only seeing possible problems as time goes by. So for us, as I'm sure every property owner in our circumstance, you've heard it before, that delay is quite harmful. Our concern as it relates to this is that it feels that this is a policy question from our perspective between two jurisdictions, or more about, and just listening today, it feels like it's more about a methodology and what the right methodology is rather than the application of a methodology. We don't get to control the methodology. We just get to control whether or not we're complying with it, whatever it is. And of course, we've worked pretty hard to try to comply with what that methodology is. We desire to and do in fact honor the need of both of these jurisdictions to reach consensus on this important question, a question that is very important to both of them. We also feel that the conflict should not be played out using what feels to me like this is a quasi-judicial application, not a legislative matter. And ultimately, regardless of how the legal arguments and conclusions play out here, we reiterate our readiness and willingness to do whatever is legally required of us. And our hope is that we can move on with the approved application to begin construction of a project that we believe will greatly benefit the community. So to that end, our request is that the hearings examiner make a decision that allows for the full and complete resolution of this matter as to Neighborly Development's application. And we remain ready and committed toward satisfying our obligations in compliance with the responsibilities of a party in our position.
All right, thank you, sir.
And
Mr.
just a
Smith,
point
any
of
questions?
clarification, I think Mr. Moore should have been sworn in as well.
Didn't I?
I was.
Yeah.
Oh, apologies.
I
Okay,
was,
sorry.
yeah.
Where did I go? Okay, I have no questions for you. Thank you.
Mr. Harper?
No question.
Mr. Hume? All right, anything further, Mr. Smith?
No.
All right. Now we're turning to City of Liberty Lake for whatever presentation you'd like to make, Mr. Hume.
No, beyond the staff report, I think we'll wait to hear from the applicant. If they have a legal argument, we'd like to respond to that.
All right. From the appellant, you mean?
Sorry, the appellant.
All right.
You're the applicant.
All right, then is everybody ready to go then? We'll move on to any arguments you'd like to make. All right, we'll start with Mr. Harper as the appellant.
It's not necessarily hard to question a witness sitting down, but it's going to be hard to argue sitting down. So
Okay,
I will,
it's up to you how you want to do it. If
do you
want,
mind, Mr. Examiner, if I go?
not at all. You can do whatever you'd
It's
like.
just ingrained almost.
Sure.
I may be regretting this if everything's going to slide off the lectern. Okay, there we go. Well, Mr. Examiner, still good morning. Thanks for taking the time to listen to the testimony today. Ken Harper for Spokane Valley. I want to come to the main. Thank you so much. Genius. I want to come to the main point of the city's argument, and then I want to talk about some of the testimony you've heard and some of the exhibits as well. But the main issue that we have here is that there is a 14 building, 288 unit apartment or multifamily project, in addition to a mixed use element that is going to send 3,000 ADTs throughout the vicinity with 50 some odd percent. My figure shows 55. Mr. Salman wasn't quite sure, but approximately 50% to and from the west along Country Vista Drive to Spokane Valley. Those are the facts. The other part of the factual scenario here is that there is no analysis in the record. There is no analysis in the SEPA record, I should say, regarding the effect of those trips on the city of Spokane Valley's road network. I think Ms. Key was very clear that the applicant was provided an alternative here between paying into the Harvard Road mitigation plan or doing a TIA. And to Mr. Whipple's point, as we heard a couple of times, it's very clear that there are great advantages for a developer in paying into the Harvard Road mitigation plan. It's an opportunity to, according to Mr. Whipple, not have to take the time or spend the money to do a TIA. Well, that's fine. But what that represents under the City of Liberty Lakes approach to this SEPA review is it represents an absence of prima facie compliance with SEPA because we have tangible impacts in the city of Spokane Valley that have not been picked up by anything that Liberty Lake has done in this review. They're not picked up by the TGDL because it simply doesn't go that far. It doesn't try to. And this is no criticism of Mr. Whipple. I have no questions for him. I understand the TGDL was consistent with Liberty Lake's expectations. But it simply doesn't track where those trips go or what impacts those trips have on intersections and road systems that may be affected. So that turns the focus then to the Harvard Road mitigation plan, because that's the in lieu of option in essence that that Liberty Lake provides for this this applicant and in general. And when you look at the Harvard Road mitigation plan, or the Harvard Road mitigation program, to be, I guess, more correct, what you find is, again, precisely what Ms. Key testified to. It is a cumulative fund, to take it right at its own phrasing. It is a fund for the cumulative cost of traffic system improvements described in the plan. That's the Harvard Road mitigation plan text itself, page 34. The Harvard Road mitigation plan 2013 update at page 5 says the same thing. It's a fund that is made available for developers who voluntarily choose to pay into it as impact fees as part of the pro rata contribution of each proposed by each proposed development for the cumulative cost of traffic system improvements, as based upon full build out for the city of Liberty Lake. Whether it's clear in Ms. Key's testimony or not, I think it was, but you can review and you can make your own decision on the evidence. It is crystal clear in the staff report that the Harvard Road mitigation plan or program or payment, I keep adding different phrases to that P. I'm gonna call it the HRMP. The HRMP is not and was not intended to mitigate any specific impacts of the Neighborly Ventures binding site plan in the city of Spokane Valley. It doesn't, it can't, that was not the goal of it. And the problem that we have, Mr. Examiner, is that because it doesn't do anything, even at a general sense, for impacts in the city of Spokane Valley, it creates this fundamental, what we claim is a fundamental SEPA non-compliance because it was in lieu of the TIA or some other form of analysis that might have provided an adequate SEPA record of what impacts would be appropriate in the city of Spokane Valley. Now, we've got a criticism, of course, that you've seen in the briefing that Liberty Lake may not be lawfully using the HRMP within Liberty Lake. And we do think that's relevant, and I'll explain why here in a few moments. But I just want to highlight that when we talk about the role of the HRMP in the first instance, it's not whether it's necessarily lawful, it's that it's representative of a gap, if you will, in the adequacy of information that was necessary by the developer to assess impacts. It's also a gap in terms of establishing mitigation. It does nothing for the 55% or the 50% of the 3,000 ADT that goes west into the Barker corridor. Now let me turn to the A202-020 argument because it does pertain to one of the basic positions of the city here. There's a lot of sort of lawyer talk in the briefing about 020. I think what I want to highlight there, Mr. Examiner, is that because the HRMP is a voluntary fund, and because it has sort of this GMA impact fee type feel to it, it has to be recognized, though, that it doesn't comply with the legal standards of a voluntary payment or a voluntary agreement under 020. So setting aside the role of the HRMP for SEPA purposes, it is questionable whether that is a suitable form of mitigation, even in Liberty Lake. So let's just work our way through that. It can't be a GMA impact fee because it hasn't been adopted as such. We know that. There's no 8202-050 impact fee ordinance in Liberty Lake. Instead, we have a voluntary agreement or a voluntary fund. And according to the briefing submitted by Liberty Lake in particular, that makes the Harvard Road Mitigation Plan acceptable under 020 because it's a voluntary program. But as we've heard today, it's a cumulative fund. There's nothing in it that represents an establishment of reasonable necessity as a direct result of a proposed development or plat. That's the language from 8202-020. Now, in Tri-Men, as I'm sure you know, Mr. Examiner, the parties were dealing with a park mitigation fee. It was not an 8202-050 GMA impact fee. It was not a traffic impact fee case at all. It also wasn't any form of SEPA case. And so this keeps basically, it keeps reinforcing Spokane Valley's SEPA theme. If we have a valid GMA impact fee ordinance, I fully appreciate, I think, a shade of what Mr. Whipple testified to, that those can provide mitigation at a general level. But for SEPA to be implemented through a voluntary agreement, which we recognize as plausible, there's nothing in 020 that precludes payment of an impact fee through a voluntary agreement under 020's terms. But for SEPA to be implemented through that, it has to be a voluntary agreement that corresponds to a direct impact that has been established as reasonably necessary of the proposed development. And that's going far beyond Tri-Men. because in Tryman, the idea was that this park impact fee could be correlated to the assessed value of a particular piece of ground. And based on that assessed value, the impact fee was justifiable under 020. Well, that's not a apples to apples comparison to anything we have here, but it at least helps understand or helps explain why the court found in Tryman the payment was acceptable, because it had that correlation to the land that would have been dedicated, the assessed value of the land that would have been dedicated. Subsequent cases, on the other hand, make it very clear that something like a generalized cumulative fund will not pass muster as a voluntary mitigation payment. And one of the best cases that we can point to on that is the Isla Verde case, Isla Verde versus Camas, that invalidated a park set aside. Another influential case on that point is, bear with me here for a moment. Before I move off that point, I'll give you the quote from Isla Verde, so you've got it where you can refer to it. This is Isla Verde, City of Camas, 146 Washington 2nd, 740. The court's discussing 82-02020, and I'll just quote briefly. The court states, "We have repeatedly held, as the statute requires, that development conditions under 82-020," that's not in the quote, "but under development conditions must be tied to a specific identified impact of a development on a community." Castle Homes and Development versus City of Briar, Court of Appeals decision, 1994, at 76 Washington Ave 95. Again, 1994 case, states, under RCW 82-02020, a city must identify the development specific impacts to be mitigated. Traffic mitigation fees, now I'm quoting again, based on a cumulative impact of all the new subdivisions, not the specific impact of the Castle Crest 2 development, was a clear violation of the plain and unambiguous language of RCW 82-02020. So again, Your Honor, Castle Homes and Isla Verde would be the two key cases that we think explain why Tryman is distinguishable. We see in Neighborly's arguments reference to a couple of cases that deal with park impact fees. I just encourage, Mr. Examiner, I encourage you to read those, United Development Corporation and Common Sense Alliance. Those do explain how Tryman provides a non-site specific approach to park impact fees, but that's because park impact fees can't be studied the way traffic can. There's a much easier way to correlate a specific impact to a specific fee and thereby satisfy potentially SEPA mitigation in the traffic realm that doesn't exist in the parks realm. And so I think if you follow those cases, United Development and Common Sense Alliance on the one hand, or Tryman through Isla Verde through Castle Homes on the other hand, you'll see a clear deviation between the idea of a fee in lieu of dedication for parks versus something close to an absolute insistence that traffic impact fees, at least here in 2022, derive from GMA-based impact fee ordinances, which again, we don't have. So my point isn't necessarily to poke holes at the way Liberty Lake implements the Harvard Road Mitigation Plan. That's their business. It's not Spokane Valley's business, but it is critical when we think about whether that is a form of SEPA mitigation that, in this case, not only probably doesn't apply to Spokane Valley because it's outside the jurisdictional impacts, but also was used in lieu of actually having a TIA. Now, what Liberty Lake claims on that is that this was simply an option that their code provides. And as Mr. Whipple very candidly explains, his advice to his clients is don't do the study. If you can pay the money, pay the money. Don't do this. It takes time. And it's complicated. It's expensive. But Mr. Examiner, the Valley really challenges whether that's a correct implementation by Liberty Lake of its own code. This comes from the City of Liberty Lake design standards. This is at their Liberty Lake design standards 1.12 subparagraph A and B. This relates to transportation analysis. It's in the record. You've got access to it, of course. And in this section, the city design standards talk about if a project is anticipated to generate more than 200 trips per day or peak traffic of 50 or more trips, then a traffic distribution letter, or what we've been calling a TIA, will be required. Okay, that's fine. But this is the next section that I think Liberty Lake places tremendous reliance upon, and which the Valley does not agree substitutes for a prima facie SEPA case. It's the next section that simply states in its entirety, subparagraph B, Harvard Road mitigation is also an acceptable form of traffic impact mitigation. What does that mean? What does that do for you? If it says Harvard Road mitigation is also an acceptable form of traffic impact mitigation, it doesn't say that Harvard Road mitigation is also acceptable as a form in lieu of performing an adequate SEPA review. It says it's an acceptable form of traffic impact mitigation. Well, as I've stated, the Valley has its qualms with the HRMP as a form of traffic mitigation, but we don't even know what this clause is setting up in opposition to. It's an acceptable form of traffic impact mitigation in lieu of what? Or also in addition to what? The implication is that it's also or in lieu of doing the traffic distribution letter. That's not what the context of the paragraph says. And whether that's what it says or not, we've got state statute and state regulations under SEPA that require probable significant adverse impacts be mitigated. So I can't be more emphatic about it. We just fundamentally, and I think this is exactly what led Liberty Lake down this path. We just fundamentally reject that substitutes for a prima facie compliance with SEPA. There's been some testimony by Mr. Sailman and also brought out by Mr. Whipple's points that the traffic, I guess we'll call it the traffic memorandum of Mr. Sailman, did not account for background traffic in the Barker corridor. Mr. Sailman is very candid about that. That's true. And what that signifies, I think, to you, Mr. Examiner, is that needs to be accounted for and needs to be addressed on remand when this matter goes back to Liberty Lake for an appropriate SEPA document. At this point on this record, the testimony is that the Neighborly Ventures binding site plan will contribute 5.3% of the traffic at one intersection, that being Apple Way and Barker. If I'm correct about that, Apple Way and Barker, yes. And 1.5% of the traffic at Apple Way, I'm sorry, at Barker and Sprague. Now, in addition to that aspect of the percentage change, we have the possibility of background projects, but none of the background projects, as I think we've heard, none of the background projects have been shown either separately or all together to have the same impact. Mr. Whipple on direct exam didn't provide any testimony. In fact, what he stated, didn't provide testimony, obviously provided testimony, he didn't provide testimony on that point. What he stated was that if you accounted for those background projects, there might have been a level of service failure before the Neighborly Ventures site plan arrived on the scene. He further stated, we don't really know. And then he said what is really the heart of the Valley's whole case. He said, we don't really know because that level of analysis has never been completed. That's the key. We don't really know. On the record, we have what Mr. Sailman prepared. And Mr. Sailman had to prepare it because Liberty Lake did not require it. We also have the role of the Barker Sprague roundabout that now exists and has been completed. That's just a fact. There's nothing to argue about there on that fact. But I do want to point out that that is addressed squarely by the Town and Country Federal Way case. You're certainly familiar with that, Mr. Examiner. I'll just cite it. You've got easy reference to it. 161 Washington Ave 17, 2011. Actually styled the other way around from what I said, Federal Way versus Town and Country. It's a fascinating case, and I'm sure you'll recognize a few things from it that I want to highlight. The most important thing that I want to highlight is that one of the issues in that case had to do with the argument that certain projects were already in progress. This discussion takes place at head note 13 of the case. In terms of the internal pagination, it picks up at page 51 of the case. It's under the caption of previously planned. And what's going on in that discussion there, Mr. Examiner, is the project proponent, the Town and Country project that was being offered, recognized that various projects that it was being required to mitigate were already on the, I guess it would be the City of Federal Ways TIP. And in fact, they were underway, if I recall the case correctly. The argument was made that both of the transportation improvement projects to which Federal Way is seeking contributions have been planned for some time. And the court said that that doesn't matter. You can read the discussion, satisfy yourself, but it does not matter simply because those projects were underway and that they addressed a pre-existing deficiency did not mean that the proponent of the project was excused from answering SEPA questions, or in this case, providing mitigation for those projects. And that's exactly where we are here. With respect to the roundabout was not completed at the time the application came in. I think the roundabout construction commenced roughly July 5. I'm not going to tell you when it was substantially completed or when it was open to public. You can drive through it today. Maybe you did on the way out here, but it now exists. But it certainly was not completed at the time the application came in. That's the roundabout. At Barker and Apple Way, the key mitigation is this southbound approach widening. All we've heard on that is that it's part of the city's TIP. That's precisely what's going on in the Town and Country case. It's planned. Ms. Key made the comment that aside from the limitations of the HRMP, she made the comment that Liberty Lake didn't think mitigation was appropriate for Barker and Apple Way. I got to keep these intersections straight, for Barker and Apple Way because it was on the TIP. All that stands for is that the city recognizes the need to mitigate that intersection. It doesn't stand for the suggestion that the city should have to pay for that entirely on its own part when we have all of these trips going to that intersection that are clearly attributable on this record anyway, without any set off or background traffic, that are clearly attributable to the binding site plan of Neighborly Ventures. The other point that I think is part of the background traffic argument that I want to draw out from Town and Country is just to touch once again on that point that Mr. Whipple makes, that there may be impacts that would be adjusted by the background projects. If that's true, and that is true. I mean, the background projects do change. Mr. Salmon testified to that. It would change. Does that somehow represent a flaw in the Valley's case? And the answer comes right out of Federal Way versus Town and Country again. And the answer is no. On this record for these proceedings, what Town and Country says is that SEPA requires that we be able to identify the impact, not prove specifically what the impact is. We can sustain the City of Spokane Valley's burden of proof to show the absence of a prima facie case simply by identifying the existence of a significant probable adverse environmental impact that is not addressed in the SEPA record without proving the specific quantum of mitigation that's necessary. And truthfully, Your Honor, I think Mr. Salmon couldn't have been clear. I've already said that has to be factored in. It will have a bearing. We will be asking, I am asking for you to remand this so that can be accounted for. And it would need to be accounted for. I want to touch on the standard of review briefly. And then I want to talk about a couple of procedural things, and then I think I'm done, unless you have any questions, Mr. Examiner. The standard review, I've already alluded to it a couple of times. You're going to be familiar with this. Reversal is appropriate if the SEPA threshold determination is clearly erroneous. That's met when there's an absence of a record sufficient to demonstrate that environmental factors were considered in a manner sufficient to amount to prima facie compliance. In this case, it's a little bit ambiguous whether Liberty Lake agrees that that SEPA, or shouldn't say agrees, contends that SEPA would literally never require consideration or mitigation of impacts outside of Liberty Lake's jurisdictional boundary, or whether they would acknowledge that given a certain record. I think that's a very unclear line that's being established in the briefing. In Neighborly's brief at page 2, Neighborly states that Liberty Lake, this is a quote, Liberty Lake maintains no policy or requirement that projects mitigate impacts outside the jurisdictional boundary of Liberty Lake. I think we've heard some testimony today that suggests that that's exactly right. That Liberty Lake simply, on the other hand, Mr. Whipple has made a comment letter to Mr. Salmons that suggests that there could be impacts. They just have to be identified. They have to be backed out of this technical memorandum that Mr. Salmon has put together, implying that Mr. Salmon's pro rata contribution, which is not an impact fee methodology at all. I'm sure you appreciate that. It's a pro rata contribution of intersection improvements, might have some validity. It hasn't been studied, and it would have to address the background growth, the background in progress projects, I guess I should say. Well, I would just suggest that there's some real tension there between what I think the applicant and Mr. Whipple know to be true versus what Liberty Lake's position seems to be. And their position at least is internally consistent. If the Harvard Road mitigation plan does what they say it does, and if that's what ties their hands as they interpret 197.11.660, then it's absolutely the case that they have no policy to provide mitigation outside of their jurisdictional limits. But that can't be the way SEPA works. If that's the way SEPA works, then any jurisdiction can simply wash its hands of an obligation to take care of impacts outside the jurisdiction by saying, we don't have that policy. We prefer not to take care of impacts outside of our jurisdiction. And therefore, you're on your own and you'll have to appeal if you think you deserve some kind of mitigation. That's not our main argument. Our main argument is just that it isn't addressed on the record. There just is no prima facie compliance in the first place. Okay, Mr. Examiner, I want to touch on a couple of procedural points. And as I said earlier, I'll then stop for questions. The procedural points that I want to speak to include, I guess, really three things. One is an argument that is raised to some extent, I think, by Liberty Lake and by neighborly. And that has to do with standing. The standing issue seems to be partly a claim by Liberty Lake that the city didn't raise certain issues in its comment letter, I guess in, yeah, I would guess that would be in Jeremy's comment letter. But that's a claim of issue-specific standing. And issue-specific standing is not required under SEPA. It's not required under LUPA. It's not required under the APA. The only place that the only place that issue-specific standing has the slightest bit of traction has been in the growth boards, and even the growth boards have repudiated. There is no basis to say that an appellant has to identify in its comment letter all of the issues that it may later argue on an appeal. An appellant has to be aggrieved or adversely affected. That much is clear. An appellant has to provide comments at the appropriate time and in the appropriate way, but there's no further standing requirement. We're allowed to make arguments today, whether they were raised by Mr. Clarkson or not. The other procedural points have to do with perfecting the appeal itself, and I want to talk about those. One of those has to do with the notion that the city's appeal is defective because it seeks to consolidate an appeal of the binding site plan with its SEPA arguments. We're just going to stand in our briefing with respect to the binding site plan arguments. That really isn't something that requires testimony, and you can make that analysis as a matter of law. But for appeal purposes, SEPA requires consolidation of any administrative appeal or in any administrative appeal of an underlying governmental action with the SEPA determination. Now, SEPA goes on and it describes various types of local regulations that may excuse that linkage requirement. And if you look at that SEPA section 197.11.683, you will not find that ministerial permits are a type of local government action that can be excused from the SEPA linkage requirement. This is entirely novel by the city of Liberty Lake. The appeal of a determination of significance, a DS, yes, that can be dissociated from appeal of an underlying governmental action. But just go through the list, 197.11.680 sub 3, where the whack ends, Liberty Lake drafts on the notion that you also cannot link the appeal of a ministerial action. The argument that we make today, Your Honor, is that that's in derogation of SEPA's delegation of authority to local jurisdictions to establish their own administrative appeals. It's absolutely the case that local jurisdictions have some latitude to set up how they want to handle administrative appeals of SEPA, but the WAC 197.11.680 sets the limits for what you can do as a local jurisdiction. And there's nothing there that says you can de-link what you may call as a ministerial permit. On that point, I further challenge whether the appeal of a binding site plan, or rather the issuance of a binding site plan, is a ministerial permit. A ministerial permit might be something like a building permit, might be something like a certificate of occupancy, but a binding site plan as a substitute for land division under 5817.110 is far more than ministerial. And I don't think Liberty Lake can say it's ministerial. Even if that argument is true, what it means is simply that the city of Spokane Valley has exhausted its opportunity for administrative appeal, and all we can do now is take it to court. But I don't think that's the case. I think it's perfectly proper to link the administrative appeal of the BSP with the MDNS, and that's what we're here to talk about today. My last point on perfecting the appeal has to do with payment of the fee. There was an argument in the city of Liberty Lakes, slurring my words, in the city of Liberty Lakes briefing, and also raised by Ms. Key regarding whether or not we paid the appropriate fee or somehow otherwise failed to trigger the right to be here today. I would just encourage you to look at the fee schedule. Follow the citations in the city of Liberty Lakes brief on this point. And what you'll find is in the fee schedule. There is an item under appeals for appeal fee, singular appeal fee, $950 plus a commitment to pay the hearing examiner fees. What the Liberty Lake brief suggests is that because the binding site plan is a separate application from the MDNS, from the SEPA application, that therefore we now have two appeal events. And consequently, the city of Spokane Valley would have to pay the $950 appeal fee once to somehow account for the appeal fee, which I guess means it's our SEPA appeal in some area. And we have to pay some other amount of money, I guess $950 again, to bring forward the appeal of the binding site plan. This is not in the fee schedule. It's not in the Liberty Lake Code. It's an argument. And it's an argument that lacks any basis. It just, you won't find any grounds anywhere else in the fee schedule or anywhere else in the Liberty Lake Code regarding administrative appeals of different types of land uses. You won't find anything regarding administrative appeals of SEPA decisions. There's nothing wrong with paying the $950 appeal fee, joining as you have to your appeal of the underlying governmental action with its associated environmental decision and invoking your administrative appeal right. Mr. Examiner, if you have any questions, I'd be happy to take those.
All right, thank you, sir. Maybe just one or two. When I first read the briefing that you submitted on with criticisms of the HRMP, my first impression going through it was that you're arguing that the whole plan is invalid. And I guess I'm wondering if you're making that sort of a facial challenge to the HRMP, or is this more an as-applied sort of analysis where you're only criticizing the particular application in this case? Because it seems to me like possible I'd have to conclude the HRMP is improper before I could follow you down the path that you laid out in your argument.
Yeah, we do make the claim that it's facially invalid.
All right.
Yeah, that's absolutely right. I mean, we do it reluctantly because our primary, we're two neighboring jurisdictions, Mr. Examiner, and our primary point, well, not our primary point, but we would like to have a live and let live approach to these things. But to the extent that it is part of our as applied challenge to show that the Harbor Road mitigation plan is not faithful to 820220, yes, we are making that argument.
All right. My next question is probably broader, just a nagging. As you suggested in some of your earlier comments, I have been in this seat before. This tension is long-term. So I've had other cases with similar arguments. I'm struggling just a little bit, just analytically, with understanding what I'm being asked to do at some point when it comes to determining a fee, for example. And I'll just put it this way, and you can parse it however you'd like. In a case like this, should the applicant be required to pay the fee based on Liberty Lake's fee schedule and impact fee analysis, or whether you call it an impact fee or you call it a mitigation fee, whatever the case may be? Should they pay it based on Liberty Lake's analysis of what the fee should be on a per trip basis, for example, or should the fee be paid based on City of Spokane Valley's analysis, even though that's not been adopted in the City of Liberty Lake? So what analysis should apply? I'm never quite sure in these cases which one I should be looking at.
Well, Mr. Examiner, I think the remedy here is to simply remand. Let the SEPA process answer the question. The City of Spokane Valley recognizes that Liberty Lake is not agreeing to the South Barker Corridor impact fee approach. So we totally appreciate that. We respect that view, disagree with it, but we respect that. There is no mechanism. Ms. Key is exactly right. There is no mechanism for the HRMP to supply mitigation under this scenario. So I think your question of which impact fee applies, I don't know that either does. But I think if you remand it, then there's an opportunity to develop a record. Mr. Sailman has provided the beginnings of that. I won't say that he's concluded it because Mr. Whipple's points have to be taken into account too.
All right. So City of Spokane Valley's remedy is a remand to do a proper SEPA analysis and determine what the fee should be, given that assuming your argument is correct, determine what the impact is to the intersections that are affected in the valley.
That's correct, Your Honor.
All right. I don't have any more questions. Thank you, Mr. Harper. Who'd like to go next? All right. Mr. Smith, do you want to go up next?
Sure,
All right.
I can do that. Well, I like the presence of Mr. Harper at the podium, so I'm going to undertake that privilege as well.
Please. Yeah, feel free.
Again, Nathan Smith here on behalf of Neighborly Development on this application. This is odd, to be perfectly frank, that Neighborly Development is stuck on what really is a policy decision between these two jurisdictions to best determine what or how impacts are going to be evaluated relative to traffic. That's not Neighborly's job. That's not their role in this. Their job is to do that which is required of them. And which they did in this application. In fact, they prepared their TGDL that was sent out for comment to the affected jurisdictions, and it was commented on by the city of Spokane Valley, along with their other application materials that were also distributed. And a decision was made. A threshold determination was issued by the city of Spokane Valley, or city of Liberty Lake, excuse me, that said that the only requirement is that you pay into the Harvard Road mitigation, which they voluntarily agreed to do. The issue is, at least from a transportation perspective, is really what was Neighborly required to do here? City of Spokane Valley could have sent a letter and said the transportation costs are $1 million to the Barker Road corridor. However, Liberty Lake has no mechanism in place for which Neighborly to follow. There's no device, there's no policy, there's no plan, and there's no procedure in place that's been formally adopted by Liberty Lake that says the mitigation is necessary. And to be perfectly frank, you know, that's a conversation for another day. There have been at least 6 or 7 different iterations of the Harvard Road mitigation plan that have been reviewed and circulated. And there are annual updates or regular updates to the City of Liberty Lake's comprehensive plan that address and discuss transportation impacts associated with projects within the boundaries. Those are the legislative enactments that SEPA really requires under WAC 197-11-660. Those are the devices in which policies are in play, and they're not here. They don't exist. And so those are the things. So peeling away those layers of the onion of the kind of the policy device that really exists here, it becomes, you know, what can we do? Well, the answer is we did what we did under the MDNS because that's what our policies are. At a site and project specific level, Spokane Valley has been a little bit inconsistent in terms of what it really requires as part of this review. As we've shown in our testimony, the Harvard Road Mitigation Plan said projects south of Appleway should not be required to pay an impact fee. That's table 25 of the plan. It's $0. Second, then we have the City of Spokane Valley's comment on the application, which provides 2 different theoretical mitigations for this project. I think in the vicinity of $250,000 or $197,000. That's fundamentally different than 0. And then finally, they provided a comment after the close of the record which says that the project should have to pay $145,000. So even the City of Spokane Valley doesn't know what mitigation really is required. But what they have said in the policy that was adopted and enforced by the City of Spokane Valley in prior to and to when the application was being processed, it was $0. The South Barker Road Transportation Traffic Impact Fee study for Liberty Lake, and I apologize, it's a mouthful, was adopted after our application was processed. So it was only after the application was processed that a policy went into play. So Spokane Valley had no process and no policy in place prior to the submission of the application, and Liberty Lake has no policy or process in place during the process of the application. So there's no mechanism or device to collect impact fees. And maybe I went a little bit too far too, in terms of thinking a little bit about what's really required. And really this is a case about what did the process look like that was undertaken from a SEPA perspective? The application was sent out. The application was forwarded to the affected jurisdictions. The jurisdictions were afforded the opportunity to provide comment. And then the city made their threshold determination and issued the decision. That's prima facie compliance with SEPA. That's what the city is obligated to do. These applications are vetted and reviewed and considered as part of this process. That's the compliance. The deference that's owed to the City of Liberty Lake's responsible official says that absent some sort of catastrophic error in the SEPA review process, that the decision should be affirmed. And so I think that deferential requirement is essential to the processes that have been employed here by Spokane Valley to change and alter the level of impacts that they think might exist. I also want to speak to generally the Harvard Road mitigation plan as well. It's interesting because the argument, as I see it, is, well, we have to punt out the Harvard Road mitigation plan in order for us to be able to receive some sort of traffic impact. I don't know that those are necessarily mutually exclusive. But first, if there's a challenge to the Harvard Road mitigation plan, this isn't the time to do it. It's a legislative enactment by the City of Liberty Lake. This is not a quasi-judicial matter. In addition, the Harvard Road mitigation specifically says by its terms that it's an individualized determination as to the calculation. We've provided the trip distribution and generation letter, and the fees that were calculated, which will be calculated actually at the time of construction, are based upon that individualized determination and the number of trips that would be generated. What more individualized determination could there be? And I think it's worth noting too, that for some reason that there's some belief that you can carve up the City of Liberty Lake into a number of different independent service areas. Well, the City of Liberty Lake is like 6 square miles. You can't carve it up into multiple service areas in order to account for impacts. The purpose of the Harvard Road mitigation plan is to address and consider impacts across the jurisdiction. So I think what really is unusual is to think that there's got to be some sort of apples and oranges play here. There sure could be both. Liberty Lake may decide at some point in the future to enact a policy and enact a consideration, but it hasn't. It disagrees. So much so that, and I think this is important too when analyzing prima facie compliance with SEPA, that rarely do responsible officials take the time to tell a commenter why they're wrong in response to their comments. And I think that's critical because in this case, Ms. Key commented back to the City of Spokane Valley and said specifically that we disagree with your analysis. Well, how can a responsible official impose mitigation on a project when they disagree with their analysis? And I think we're not playing in a vacuum here where we have to accept the impacts and the analysis of the City of Spokane Valley being true. That's not the case. In fact, they were considered and reasoned as part of the MDNS process. And if the City of Liberty Lake agreed with them, and if the City of Liberty Lake had a policy in place, they could have imposed the mitigation, but it didn't exist. And I'm not unsympathetic to Spokane Valley's claims that maybe there are some impacts, but this is not the right time in order to consider that. I also want to speak to kind of the binding site plan arguments and standing components too, because I think the City of Liberty Lake has probably their positions on some of my commentary too, which is, first, I don't agree that standing is an all or nothing proposition. Okay. The City of Spokane Valley's comment letter to the City of Liberty Lake is entirely devoid of any sort of discussion about the land use decision that is being made by Liberty Lake. I mean, it may use the word BSP at some point, but it does not comment or make any sort of note that in fact the mechanism is not proper. And I don't think that, you should be able to have a surprise attack post the issuance of a decision to say that the land uses decision is incorrect or the vehicle that has been employed is usable. So our assertion is essentially that they lacked standing because they failed to exhaust their administrative remedies in this case. And there's a pretty good case called Thompson versus City of Mercer Island, in which a notice of application was sent out, much like the City of Liberty Lake, and people were invited to provide comment. And in one appellant failed to provide a written comment when afforded the opportunity to do so, and under LUPA lacked standing to challenge the land use decision. That's exactly what we have here. City of Spokane Valley just decided that we're gonna put all our eggs in the basket of using SEPA as our vehicle, and maybe there's a binding site plan issue, or maybe there's not. So Liberty Lake incorporates the LUPA standing requirements into its code too. So that's how we get the linkage that exists between the two of them there. I also just, as a matter of kind of principle, I think it's a little bit disingenuous for Spokane Valley to suggest that a binding site plan is not the appropriate mechanism to buy the land. They do it too. They provide binding site plans for multifamily uses. Their code says in the mixed use zone. Those devices are all exactly the same. So I think the reality of it is this is an issue about SEPA, not about the vehicle in which the land use decision has been made. I think it's difficult to see otherwise. And then the remainder are procedural issues, one of which I think is important to note, that Liberty Lake never made a determination of consistency. It's actually in their notice of application. When they said that the project was consistent with their land use goals, and they went on to describe 6 different processes that were identified. So they checked the boxes that were required from a land use decision perspective to approve a binding site plan as permitted by their code. So really it comes down to what's the SEPA issue. That's outstanding. So I think with that, I will conclude my remarks. Should you have any questions for me, kind of the innocent party in the room being the land use applicant here, I'd be happy to entertain them.
Thank you, Mr. Smith. I don't think I have questions for you.
Okay, thank you very much.
Thank you, sir. All right, Mr. Hume, seeking the comfort of the pulpit as well.
Okay, for the record, this is Todd Hume speaking on behalf of the City of Liberty Lake. I think we've trodden on a lot of this ground between the briefing and the testimony already today. And so some of the issues, there's a bit of fly specking that's going on here on behalf of the City of Spokane Valley on some of these issues. And I think, for example, I'll rest on what the staff has done in their staff report and the presentation earlier. I do want to focus on the larger issues. That's really why we're here. Mr. Hearing Examiner, as you know, this is what I'll call round 3. So this is the 3rd time we've had this issue where the City of Spokane Valley has appealed the SEPA determination on a project inside the City of Liberty Lake. This project is inside the City of Liberty Lake. The City of Liberty Lake's code controls, not the City of Spokane Valley's. And as we've established today, there is no interlocal mechanism available to share fees. The request that came in when Ms. Key was processing the application was for there to be the imposition of fees. As she analyzed that, and I don't want to sort of speak over her testimony stands for itself as to what she looked at. But as she analyzed that, she looked at a couple things. If you hearken back to her testimony, what's the condition on the ground? So there was one intersection, which I believe was Barker and Sprague, that was almost under construction. The traffic expert from the City of Spokane Valley even said today that that intersection would be functioning at an A, right, in terms of level of service. The other intersection is Barker and Lisa, help me out. Appleway, thank you. Barker and Appleway, which is just north of that, the previously mentioned intersection, which is funded, completely funded and ready to be revised. So when the responsible official was being inundated with information from the city of Spokane Valley, her consideration, right? Remember, again, we're talking about what was considered under SEPA. There's not an outcome that's required of SEPA. It's the consideration of environmental factors. That's why I asked Ms. Key, what did you consider as it relates to traffic? And the record is full of documents she considered, analysis that she put into whether or not this would be an appropriate mitigation to require. At the tip of the spear on that was the city of Spokane Valley was asking for fees, and she knew that she couldn't levy fees. They were asking for fees on an intersection that was about to be built, that was about to be fully functioning at an A level, where there was no interlocal in place. So I think there is a prima facie showing on behalf of the city of Liberty Lake that Ms. Key considered, that's all that's required here, considered environmental information sufficient to show that it was considered. Again, there's not an outcome that's required here. On the issue of standing is important, and standing is include the definition for standing, which comes from LUPA, is included in the city of Liberty Lakes code. And so it essentially requires two things. You know, was this in the zone of interest, and is there an injury in fact? And there are issues that the city of Spokane raises where they were not in the zone of interest for the city of Liberty Lake to consider, and they have not demonstrated an injury in fact. For example, the Harvard Road mitigation payment, they have spun that into the city of Spokane Valley standing up here and saying, we want you to declare that mitigation plan, that impact fee plan that Liberty Lake has is not valid. Of course, you can't do that. That's a legislative act. It's not even in front of you. I don't think you have the jurisdiction to do that anyways. They don't have the standing to interfere with a contractual relationship between the city of Liberty Lake and an applicant. And that's what they're trying to do. Thinly veiled, what they're really saying is, hey, those impact fees are going to the east, they should be going to the west. And so we don't want them to go to the east. And if you think that's what mitigation is for this project, you're wrong. So we're going to attack the Harvard Road, the imposition of impact fees to go to the Harvard Road mitigation plan. So they've spent a lot of time trying to attack the plan itself. We contend, the city of Liberty Lake contends, that they do not have standing on that issue. They also talked about, Mr. Harper talked about a number of cases, one of which was the Tryman case. And I do think Tryman's instructive here. Tryman is not a traffic case, that's correct. Tryman is a park mitigation fee case. But the argument tracks almost exactly what's going on here. And I'm just going to read a couple of quips from Tryman. So this is, for the record, Tryman Development Corp versus King County, 124 Washington 2nd, 261. It says Tryman next claims that King County violated 8202020 because it imposed the in lieu of fees without first identifying the direct impact or result of the proposed plat. That's the argument that the city of Spokane Valley argues. You can't demonstrate a direct impact. Tryman claims that King County's failure to identify a direct impact of its development before imposing fees violates 8202020. Again, the same argument. The court says King County conducted a comprehensive assessment of the park needs in the 1985 report entitled Interim Assessment of King County Park Needs. The report indicated that there was a deficit of approximately 170 park acres in the North Shore area serving the Westchester Hills 1 and 2 subdivisions. We conclude, therefore, that the impact fee imposed in lieu of dedication were reasonably necessary as a direct result of the proposed development. In other words, they needed the study. That's why I asked Ms. Key about the study. What is the Harvard Road impact fee ordinance based on? And she gave a response about the numerous studies that go into that. It's a small area. Again, the 6 mile area is a fairly small area compared to the city of Spokane. We have impact fee areas that are much larger. So Tryman would tell you, I believe, that the fact that there are studies that support the plan in and of itself, that is the impact. Okay. The failure to properly file the appeals So the city of Liberty Lakes contention is that that there were two applications here. There was a SEPA application and a binding site plan application. They rolled those both into one appeal by paying one appeal fee. If you look, when you look, Mr. Hearing Examiner, at the fee schedule, there is a section at the very end called fee administration. Section 3 states each action for which there is a listed fee above will constitute a separate action, and the fee will be computed as determined above, i.e. each variance request is a separate action. So our position is a couple of things. One, to the extent that there was consolidation allowed, nonetheless, there was only one fee paid, which under the code means that one of those applications, one of those appeal applications was not valid, was not perfected. Which one that attaches to? That's a good question. I don't know. I mean, they paid one fee and two appeals. The other piece is that it specifically says, as Mr. Harper was alluding to, it specifically says that you decouple those appeals. It's not to be, a ministerial permit is not to be appealed with SEPA. That when you look at the code and what the binding site plan is, it's an administrative interpretation, it's administrative determination by the planning director. And we believe that type 1 permit is the type that would be decoupled from SEPA review. If that's the case, then they would have to go out and do the SEPA review separately. The 14-day window has passed, and it's too late to do that. So those are a couple issues that you'll have to wrestle through, but that's our position on that issue. Again, not going into the weeds on some of the things that were in the staff report. I think the record demonstrates that Lisa Key analyzed any information that the city of Spokane Valley was going to give her. I think she also had additional information at her disposal as to the condition of those intersections. And there is the issue with respect with the Mr. Whipple raised with respect to timing, where figure 25 told them at the time of application that there was no impact fees to be levied south of Appleway. The day before the appeal period runs, after all of the work has already been done, they pass and we're all going to get this confused, the South Barker impact fee rate study for the city of Liberty Lake, which was adopted after the application, after the consideration of the responsible official, after the determination was released, that pulled that figure 25. Nonetheless, you'll find in there that it says only 2% of the traffic in the city of Spokane Valley will go to those intersections. They kept that piece in place. I think the timing of that and the consideration of everything else that Ms. Key had at her disposal does show a prima facie consideration of the environmental impacts of this project. I don't think there certainly is no mechanism available to us that would allow the city of Spokane Valley to impose its impact fees. I think we all acknowledge that. I think the city of Spokane Valley acknowledges that. So I think the question that's before you, the big question is, excuse me, was there an impact? Or was there something that otherwise the city of Liberty Lake should have considered that they didn't? And I don't think there's any information today that we know today that we didn't know at that time. So I think she considered everything that was available to her at the time. We need to give deference to the responsible official who's in charge with applying the city's SEPA standards. And we'd ask you to dismiss their appeal.
All right, thank you, Mr. Hume. I do have maybe one or two questions for you. Before we do that, is the mic popping? Is that Mr. Hume's mic? You know? No? All right, I was going to swap it out if it's going to keep doing that. All right, anyway. All right, so just maybe one just general question about how SEPA works. I guess I might just ask it this way. Is it the city of Liberty Lake's position that SEPA is purely procedural? I always understood the distinction between NEPA and SEPA. NEPA is a purely procedural act that requires a process to be followed and doesn't have a substantive component. Whereas SEPA does have some substantive components, at least my memory serves that's the case. I'm not sure, but it seems like in your arguments, you're saying consideration was made. In other words, they went through the process of considering the comments. You said something about this is not outcome driven. So are you saying that SEPA has no substantive component? It's purely a process?
There is substantive authority legislatively granted to the responsible official under SEPA. So the responsible official can implement mitigation as a result of the SEPA analysis. But SEPA, the case law behind SEPA tells us that it's not, there is no required outcome. It's just to consider the impacts to the environment to the extent that everything has been considered. That's what we're talking about, prima facie compliance. Prima facie compliance says, did you consider these issues? And the city of Spokane Valley would essentially flip that on its head and say, well, if you disagree with us, then you haven't prima facie complied with SEPA. And our point is, well, no, we prima facie complied, and that's the only obligation we had under SEPA. But yes, there is the substantive authority available to the responsible official.
So, like I said, I don't mean to delve into things that are philosophical, but what is consideration? What does that mean to consider something? And the reason I'm asking that is because I'm not entirely sure. There are statements in the testimony as well as in the arguments that the city of Liberty Lake did consider the impacts on the valley, essentially. But I'm not sure what that means. I know that they reviewed the material. It seems to me that there's a legal conclusion that was drawn that it wasn't necessary to take this step further and actually look at the impacts within the city of Spokane Valley. And because that legal conclusion was made, nothing further was required. So that was the consideration as I understand testimony. Am I wrong about that?
Yeah, the consideration is what documents. So on a base level, what did you consider? What did you look at on this particular issue? So
That's easy. That's a check the box.
Right. And so the SEPA cases that we see that, that say there was no consideration, it's, hey, you completely missed this wetland. There's a wetland here. Nobody even looked at it.
Right.
Right. So our position is, as it relates to the two intersections inside the city of Spokane Valley, the city of Liberty Lake, the responsible official was provided with that information. That information was considered as a part of the analysis for mitigation. I think our briefing talks about this. And I think Ms. Key's staff report does a good job of saying, look, I was kind of hamstrung by 197.11.660 because it had to be based on, an active policy in place at the time. It had to be reasonable and capable of being accomplished. There couldn't have been other, or stated differently, if there were other studies or in this case, work in progress that would otherwise mitigate this, I can't require the developer to double up on that mitigation. So she was saying, hey, at the time you applied the Harvard Road study as it relates to Liberty Lake, which by the way, we completely disagree with the methodology anyways, that was not in place. So I'm not going to consider that. B, I know that these roundabouts are funded and they're being fixed. So I know that there's something else out there that's going to fix this problem. So I'm not going to ask the developer to double up. And finally, what the city of Liberty Lake or the city of Spokane Valley, keeps asking for is impact fees, right? So they just want to check. What they don't want, I think Mr. Whipple will agree with this. What they don't want is the applicant to go out and do a TIA and say, okay, well, now we're going to fix these little problems. They've got the solutions in mind. They just don't have them, maybe they want more money for it. So that's what she was considering at the time. That's what that means.
Thank you, Mr. Hume.
Okay.
Mr. Harper, you have the last word of the day. If you want to make any reply.
I do want to make one comment. I'm not gonna go all the way to the lectern to do this.
Sure.
I want to speak, actually, I just can't do it.
Old habits die hard.
Okay, yeah, they really do. Just really quickly, I do want to comment about the issue of standing. I should have brought this up when I spoke earlier, but the key case that I think you want to look at on standing is Wells versus Western Washington Growth Management Hearings Board. I think you ought to have that citation where you can pull the case later. It's 100 Washington App 657. Mr. Smith talks about the issue of whether standing was sufficiently invoked in Thompson versus City of Mercer Island. The difference there, Your Honor, is that there was no participation at the comment stage, at the written comment stage in the Mercer Island case. It wasn't a case about issue-specific standing. And when you take a look at the Wells versus Western Washington GMHB, you'll see particularly at 672 and 673, the clear refutation that standing does not mean issue specific. It means you have to raise a comment if it's required at the level of the matter being challenged, which is exactly what we did. And I do just also want to encourage you, follow the citations on the fee schedule, which you've already acknowledged you will do, and you'll understand why we have perfected our appeal paying the properly identified $950. That's all I have. Thank you.
All right. Thank you, Mr. Harper. All right, Ms. Thompson, do we have any procedural questions or issues of record that we need to discuss?
No, we do not.
All right, I think I have everything I need to make a decision in the case. No one's asked to keep the record open for additional testimony or information. Thank you, everybody, for a very professional job. I appreciate it very much. I'll do my very best. I realize the applicant is in a hard spot. I do find that to be very unfortunate. It just is. This is true in every case where two jurisdictions are fighting. But I'm tasked to make a decision in this interjurisdictional battle, and it comes out however it does. But I do sympathize with the applicant's situation. Anyway, thank you, everybody, for participating. We are adjourned.